All right. It being a couple minutes past 10 o'clock, it's time for us to get started. For those of you in the audience and sitting and paneled, what we're going to do is we're going to go through HB 103 FN because it was scheduled for last hearing and we just never got to it. So we're gonna do that first. There's some issues to work through there. And then we're going to go into 1677. Now, those of you who aren't on Division 3 for 103, I respect you as individuals. If you have something you want to ask, go ahead. I think if we have a vote, we'll probably limit it to the folks who are here representing Division 3, though. So my goal is to get through 103 in an hour or less. And in order to do that, we're going to need the department to come up and get us started. And then I think Representative Erf has spent a lot of time working on an amendment. And so with the department still at the table, I'd like to be able to ask you questions as we walk through the IRF amendment to see what you know about it and what you think the implications of the amendment are. There is a similar bill to this in the Senate, Senate Bill 422 FN. I might do something a little unusual and pass this out because this is kind of a competing bill. And so one of the things that I need to figure out, and I would benefit from having input from Division 3 certainly, is what to do about their bill and 103, whether they should be merged or what. So we'll take a look at that. And so with that, we're ready for the department to come forward.
Good morning, Mr. Chairman, members of the committee. Henry Lipman, the Medicaid Director for the record.
Good morning. Dr. Sarah Finney, Medicaid Dental Director.
Mr. Chairman, if I could, you mentioned 422. I don't know if the version you have reflects the amendment in committee where they wanted to add some language to have the $1,500 cap similar to what I think Representative Erf's amendment. I don't know if the language is the same, but that was in committee when they voted at Senate Finance.
I think the odds are good because the version I have says as amended by the Senate.
Great.
So.
Where would you like us to start?
Well, I sent Dr. Finney an email. I don't know if you saw it,
Yes.
Emphasizing that this is and so if you all could just walk through the bill with an emphasis on the financial inflows and outflows. That's what our primary concern is. We have Division 3 has a deal with HHS. In the past, the two committees operated with a firewall between them. They did policy, we did finance. And with the agreement of Chairman Pearson, I've encouraged them to think about the financial implications of any policy bills that they're seeing. And then similarly, he said, we shouldn't be funding bad policy. So we have our primary lane of responsibility, which is the financial part, and that's where I'd like you to focus. But if we dabble in policy along the way, that's okay.
Representative, would you mind if we fielded your questions first and then went through it a little bit further.
So it's your testimony,
Sure.
and you can do whatever you want. You got a hot mic, and what I gave was just sort of some teasers to make sure that I had communicated the distinction between us being a policy committee or a finance committee, and I just that was really the purpose of my email.
Very good. I think just would emphasize one of the cost control measures that I think you'll see that was reflected, I think, in the Senate's Finance Committee amendment and Representative Earth's amendment is that, you know, structurally putting in a cap of 1,500, and that if that were to change, that we would need to go through a process of getting fiscal approval and GNC approval. I think, you know, where we understand in terms of where this dental benefit has not got over the finish line has been concern over costs, and we want to be upfront that we get that, and we want to work with the committee to make sure that you have confidence in the cost component of this. In 103, one of the factors that was identified is, you know, how do we, you know, in fact, limit expenditures around the benefit would be limited to certain groups, and then again on medical necessity. I'll let Dr. Finney describe it further.
Right. You know, one of the limiting factors was to say that the denture benefit would be available for individuals in the DD, ABD, and CFI waivers and nursing facility residents. So that is one self-limiting factor there.
Okay, so could we avoid acronyms? We're not as familiar with it as you are, and plus we have the public listening in.
Okay. The developmentally disabled waiver, choices for independent living. Waivers, and then also nursing facility residents would be able to have the denture portion of the benefit.
It's still subject to medical.
And that is also subject to medical necessity. So for instance, if someone is only missing one tooth, they may or may not really qualify for some type of replacement if it is not, you know, hampering their ability to chew and function. So, you know, that's an important thing to understand, that there does have to be some medical reason why the replacement is necessary.
Are you, I just am curious how granular we've gotten. Do we know what the incremental projected cost would be of just the denture part of this bill?
By limiting it, my recollection, it was about a $500,000 savings in terms of the annual cost to this group.
Okay, so we save it all if we don't pass the bill. So I'm curious what the incremental cost is. Is the incremental cost of the dentures $500,000, $1 million a year? What do you have any numbers on that, Mr. Lipman?
If you give me a moment, I'll see
Okay.
if I can pull it.
I just want to get that stuff into the record.
And it will also vary with the population, you know, so it is going to be an estimate based on, you know, the pool of individuals that are included in this benefit. Another point that we did want to make, because sometimes there's a difference in what people see as the adult benefit and the children's benefit. The children's benefit, or the pediatric benefit that we have always had here in New Hampshire, actually covers individuals up until the day before they turn 21. So the individuals that we are talking about for this adult benefit are 21 and above. And so we need to be very careful when we look at enrollment numbers that are given by the department, that we divide the population according to those ages. In some instances, folks think that once an individual turns 18 or 19, they're then considered an adult, and in some ways they are. But in terms of the dental benefit that we have here in state, the pediatric benefit goes up to 21. And another way that the benefit is being limited is by the cost sharing that was put into play in this benefit. And the specifics of that cost sharing are that individuals who are over 100% of federal poverty level would make a 10% copay based on the cost of the visit. And that amount that they pay annually is capped at 5% of their annual income. And that includes any type of medical copay that they have. It would not just be from the dental benefit. So, for example, if an individual is also having to make copays for pharmacy costs, that has to be brought into the calculation of how they reach that 5% upper limit.
So do we currently have in law the copay for pharmaceuticals for Medicaid? Is that already in the law?
We do, it's a de minimis one, really, it's $1 or $2 per prescription currently. So in terms of absorbing a lot of the 5% of income, it's unlikely to do so, except someone who's on a lot of medicines.
Oh, okay.
What was the figure?
It's either $1 or $2 is the co-payment on prescriptions.
And then for the dental visits, it would be 10% of whatever the cost of the procedures are that day.
So if it were a $200 procedure, they'd pay 20? And then could you just talk us through who's going to do the collections, who's going to keep track of whether the ceiling's been reached? What are the mechanics of that?
So in testimony, I think earlier in the process here, I don't think it's uncommon for, if it's done through the MCOs, if that's what the approach is, that they're able to do that. If it was done through an entity like a Delta Dental, which is a sort of a freestanding unit, that both parties had indicated that that's something, coordination of benefits is not something that is foreign to them and would be able to be done. So in terms of tracking whether they're up against the limit, there'd be obviously coordination between the department and either the MCOs or the dental MCO. And in terms of collecting the actual dollars, that would be at the provider level. And that makes up their payment. So if they were entitled to a $200 payment, the $20 would be collected from the patient. And typically, if people who have commercial insurance, that many of the practices expect the co-payment before the service, and I would see that it would work somewhat similarly.
So somebody's going to have to receive their financial information, like their annual income and all, which opens up some privacy concerns. Can you just talk a little bit about what we're going to do to respect privacy of this financial information, or is this a new issue, or just something we've already been dealing with in other areas?
It's something we already deal with. I think as part of applying for Medicaid, you have to make financial disclosures to determine eligibility, and so that we wouldn't necessarily be disclosing someone's income directly to anybody other than within the department. In terms of just accumulating what would be a threshold, would be what would be going on behind the scenes.
So the receptionist that's going to, or administrative assistant who's going to receive the patient's money at the point of care, how would that administrative assistant know whether to collect $15 or $22.20? I mean, if it's a 10%, it's got to be that sort of seems to want to be calculated at the point of care.
Right, and so you don't need their income to calculate whether what the 10% would equal to. It would be that if you collected a copay and say that the 10% and it was greater than, and it turned out that they had been paying a lot of other things, then they might either look up in the system, providers can go in the system and look up a patient's situation, or they may potentially, after the claim is processed and adjudicated, may need to make a refund if they collected too much. Similar to commercial insurance, where you have deductibles and copays and limits, if you will, on how much out-of-pocket costs someone has.
All right, have you told us everything that you wanted to tell us coming in here today?
I think we had some more that we wanted to
Okay.
address, and I do have denture information. I have it at a detail level. I just need to do a calculation while Sarah's telling you something else.
All right.
I believe one of the other questions that you had was to specify what the federal share would be versus the state share. So in general terms, for this benefit, the standard Medicaid population is a 50-50 match. So it's 50% federal, 50% state funds. For the expansion population, which is granted Advantage, it's a 90% federal share, 10% state share, and that 10% comes from the health trust fund. So it's not a general fund expense for that 10%. And do you have?
Just from a population standpoint, our assumption is there'd be 51,143 people who would be having their coverage through on the 90% level, and 37,085 people who would be at the 50% level. At people who would be where the state would be collecting the 90% match was 51,143, and where we would be receiving the 50% match would be 37,085 individuals.
Would you remind me when and if the expanded Medicaid sunsets? When does that go away?
December of '23, unless there's an action by the legislature.
And then, so based on this, your understanding of this bill, would that 51,000 or so just drop off of eligibility?
If there was not a continuation, yes.
Do you have more you're prepared to tell us?
I did want to share with you, according to the cost estimate for a full year of coverage for the standard population, the cost to the state is $5.58 million, so that's 50%. And then for the expansion population is $1.32 million for a full year. Now, the way the bill is written, there is an implementation date of April 1st, 2023, which means that there's 1 quarter expense in fiscal year 23. And so for that quarter, the state portion of the standard population would be 1.4 million, and for the expansion population would be 0.33 million, again, coming from the trust.
1.3 million for the expansion. Cost estimate for the population, was that 5 million?
5.58 for the standard.
If you have that in writing, if you could hand it to us at some point.
Sure.
What's the other questions that we have? Oh, yeah. So I think pent-up demand is one other factor you wanted us to address. But before I do that, there's, in terms of the current funding of Medicaid expansion grant Advantage program, that the premium tax that's collected on those policies, because they're commercial policies, the 2% tax that applies to all policies in the state, that tax under the existing granted Advantage program is used to offset the cost of the program. Similarly, it could be done in this instance as well, that the tax would amount to a little over $400,000 on when it's fully implemented, and it's paid, the tax is paid, the first tax payment that if we were to continue that practice would be not until April of '24. And so I think the other question you had was related to pent-up demand and the factor that was included in there. And Sarah, you might talk about that just a moment.
When the pent-up demand was calculated in this cost estimate, the actuaries are basing that on a typical Medicaid population, which is going to be different than a commercial population. So in the patient mix within the group of individuals that's going to be insured, we know that this population is coming into the benefit with heavy needs because they haven't had the full benefit prior to this. And so that is included in our calculation for the cost estimate. As time moves on, that will be adjusted. Part of the reason is that this is written to be a value-based benefit. And part of value-based benefiting is incentivizing for both, provider and client, an improvement in oral health over the time of the contract, so that part of the contract will drive down the pent-up demand, because they're going to be made responsible, the vendor will be made responsible for making sure that they meet certain requirements that we set in the contracting of the benefit, so that year over year, more individuals are coming in, having the preventive care and the restorative care that they need, and then maintained throughout the course of the year. They don't just drop out. And so that will help to bring down that pent-up demand and will adjust the cost. It's hard to tell. Is that going to take 1 year, 2 years, 3 years, 4 years? Obviously, we want to see that pent-up demand disappear as quickly as possible, but, that's, I can't do more than estimate what that could be.
So I think we've talked about this hallway conversation. I am a believer that the pent-up demand isn't quite as large as we might otherwise anticipate, because one of the MCOs providing 22% of the care has been providing a dental benefit, and they experienced some adverse selection when they first made that dental benefit available. So I'm good with the conservative estimate that you all have put together. That's the right way to go. No surprises are good surprises. So, but I just think our actual experience, it's not going to be as bad, because I think 30%.
I think that you're right in terms of trying to be conservative about what it could be, so that we don't underfund the situation, but also, since we don't have experience, having to rely on other states' experience, through our actuary to develop that estimate. I did look at the detail on the dentures in the waiver populations. The use rate is expected to be 8 individuals per 1,000 enrollees. We're talking about the 37,000 enrollees. So it's 8 times 37 would be, I'll give you a number in a second, Representative Weil. But just so you understand how I'm coming up with the number, it's basically expected 8 times per 1,000 people enrolled. So we're talking about 37,000 individuals who fit that category. And so in terms of what the cost based on the actuary's number would be, about $175,000 for that population annually, taking into account administrative costs and taking into account the premium tax.
All right, thank you. Again, if you've got that written down somewhere, that'd help the clerk make sure we got that accurately.
We can,
So, I'm assuming you've said everything that you intend to say today, because I'd like to open it up for questions from other people, just to make sure.
sure, that'd be great, and I guess just would close with saying that I think the range of amendments that we've seen are all ones that we could work with to deliver a cost-effective benefit with cost controls.
Great. I want to have Representative Erf. Well, wait a second. Division 3. Does anyone have any questions about HB 103? You'd like to ask now? All right. So, Representative Erf, do you want to walk us through your amendment? Specifically, what do you see? Focus on the changes, really.
Thank you, Mr. Chair. So I'll be referring to my amendment, what I refer to as the Edwards Amendment, which we also received, and then HB 103 itself. And I'll be describing the changes between my amendment and both the original bill as amended by the House and the Edwards Amendment that we received prior to the last meeting. The Edwards Amendment addressed the changes that we agreed to at the meeting prior to the last one, many of which were being discussed by Mr. Lipman and Dr. Finney here today. So the first change is improved wording, for which I owe thanks to Mr. Ripple, who worked with me on this. So I'm referring now to my amendment. These changes appear on page 1, towards the bottom, lines 21 to 27, and lines 31 to 32, and on page 2 in lines 5 and 6.
So, could you pause while we look at 21 through 27, since you highlighted those?
Yes, and I'm actually going to address each of those sections
Oh, okay.
individually.
Oh, all
and
right,
you
go
can-
for it.
I'll stop after that if you want me to as
Go
well.
for it.
So now that DHHS is moving into into the contracting phase, as the work group has put forth their recommendations, the description was changed to correspond to this phase of the process. Essentially, the word model was changed to contract or organization as appropriate to reflect this is the contracting phase with an organization. So this can be seen on page 1, lines 21 to 27, what's referred to as section 2, the first 7 lines of section 2, have been rewritten to make these changes. These correspond to page 1, lines 20 to 26 of the original bill as amended by the House. So I'll gladly stop here if you'd like for a moment, if you want to look at those, at that paragraph.
If you could just clarify what, with some precision, what you think changed,
The word model
you know?
changed to contract or organization, essentially. So if you look back at 103, the original bill as amended, it talks about a model and so on and so forth. We're really
Yeah.
we're not in that mode anymore. We're
Okay.
talking about establishing contracts with
so-
organizations.
So is it fair to just consider that a semantic cleanup?
I would say that's accurate, and if Mr. Ripple wants to nod his head,
Yeah.
since he wrote this.
And the department doesn't have an issue with that? You've seen this, you've thought about it? Okay, go ahead.
I don't see the word contract.
Could you point to the line?
The word contract will come in the next, there's some more lines that changed with regard to this change. So the change you see in the first 3 lines is relative to organizations as opposed to model. So let me I'll get you to the contract.
I think that's the main point. that
So
this makes.
the last 2 lines there, section 3, lines 31 and 32, similarly, they were rewritten. Again, just for clarity and to talk about organization. Now, the next line is where you'll see contract, the next page, line 5 and line 6. So in line 5, for the appropriate model was deleted and simply says now capitalized rate, capitated rate, excuse me, for the contract, as was in the original. And on the next line, where it said, used to say managed care model, now it says managed care organization. Continue?
Yes.
Okay, so the second change, as it relates to the Edwards Amendment, on page 1, lines 16 to 18, that amendment replaced "and other services as determined by the commissioner" with a reference to current dental technology codes. You may recall this, we had a pretty long discussion with Dr. Finney about this. And when I dug a little deeper into that with the help of Dr. Finney and Mr. Lipman, it turns out these codes are not generally available to the public, as they're behind a paywall, a pretty expensive paywall, on the web. Dr. Finney agreed that DHHS could make the updates to the relevant CDT codes available on DHHS's website. And page 2 of my amendment, lines 26 to 27, reflect this. You'll see the last sentence there says annual updates to the CDT, and sorry for the acronyms, but that's as it is, shall be made available on the Department of Health and Human Services website.
May I ask the department a question here?
Of course.
Okay, so what do we think about the likelihood that in the next 10 years, the CDT references will change and given that we're being so precise in this bill, does that mean that we're going to have to come back and a future legislature is going to have to update the statute?
No, I think the only way there might be a change is that in dentistry, we may start using diagnostic codes, but that would be in addition to the current dental terminology. The American Dental Association owns that code set,
Yeah.
and it is the best way to describe every single procedure that we're doing, and I personally would be shocked if that ever changed, because it's the standard for describing procedures and is used throughout the insurance industry. It's not just Medicaid or commercial. Everyone is using those codes.
Okay, thank you. Do you want to go on?
Yes, sir. So the third change is on page 3 at the top. This is referring to my amendment, lines 1 to 3. A new section 5 is added to the list of dental services being the section we're in, clarifying that the individual annual benefit is capped at $1,500 per year, with an allowance for adjustment with approval of the fiscal committee and governor and council. This $1,500 per year cap is exclusive of preventive services, and this cap is already incorporated in the plan developed by DHHS. And I'll pause here, Mr. Chairman, if you'd like to verify any of that. Anybody else?
Section 5 is actually on the next page.
On page 3, top of page 3, sir.
Oh, well, that's 5, okay.
You're welcome. Okay. The fourth change is I'm going to describe as follows. So given that this is a new Medicaid benefit, this entire process here, it seemed reasonable to incorporate all relevant parts of the benefit into a single place. So there's no need to refer back to previous chapter law in the future. Remember, the future may be 10 years, 20 years from now. To this end, the work group language of the current chapter law is repealed and reenacted in a new section 4 on page 3, lines 23 to 37, and then continuing on page 4, lines 1 to 6. Okay? Then, go ahead.
And this is a section that you've worked with Mr. Ripple, and we validated that this comports to what we need to do to clean up the statutes.
So, as Mr. Ripple extracted this from the chapter law and put it in here, and again, he can nod his head if there's any.
Thank you.
Okay? Okay. So the final change, also on page 4, line 7 to 9, is a new Roman numeral 3 subsection, which sunsets the work group when their work is complete based on the selection of an approach for administering the Medicaid dental benefit. And that concludes my statement of the changes.
Thank you. I'm probably confusing myself with the effective date on page 4, lines 12 through 14. I was expecting to see April 1, 2023 written in here somewhere, and Mr. Lipman.
You may remember that I think there were the work that we have to do to get the state plan in effect, not the actual effective date of the benefit was where that suggestion was made in the last work group session we had with you.
Right, that you have homework to do to get it ready by
Yes.
1 April.
Yes.
Okay, but do we need 1 April in the IRF amendment listed somewhere, described somewhere, and is maybe one of the key effective dates?
It's on page 2, line 5 of the bill.
Page 2,
of the
line
IRF amendment.
5.
Representative Ayers
I see it.
amendment. Yep.
Thank you. Public.
I'm just wondering if the sponsor has, if you've consulted with the sponsor around these changes and how the sponsor and how the Health and Human Service Committee feels about it.
I was just about to walk through that very thing.
Okay, great.
Do you have any other questions?
Nope, that's just
Okay,
those are my questions.
so we'll go in order with the department, and then I'll go back to Representative Shapiro, who has been bird dogging this thing for a long, long time, along with Professor Representative Jeff Salloway before him. So we have a legacy here to the department. The question is, are you comfortable that you've participated in this amendment process brought forward by Representative Erf, and are you comfortable with that these changes are good and effective?
Yes.
Yes. Representative Shapiro, Dr. Finney, do you want to also say yes or no?
I would love to say yes, and I appreciate all of the time that everyone has devoted to trying to work this out and to understand and give us an opportunity to answer all of your questions.
Okay.
So thank you, yes.
You're very welcome. You've been doing great work. So Representative Shapiro, there's a mic along the side here. Why don't you just sit, like 2 or 3 chairs in? Yep.
Thank you, Mr. Chairman. I remember when we put an appropriation in last year for a dental benefit, and you got up on the floor and said that it wasn't vetted properly or adequately. Now we've really vetted this tremendously. So I think we've certainly examined this in ways that we hadn't examined at that point. And I want to thank Representative Erf for a lot of clarifying language, especially putting the $1,500 cap in, which is what the actuarial estimates were based on. And so looking back, it's hard to believe that we didn't put that in earlier, because that is a significant part of describing the benefit. So I thank you for that. My one question, and I think this is just wondering about the intent of the change on the top of page 3, where it says the cap will be subject to to change that cap? Or are we inviting them to kind of renegotiate the whole thing, should it go before those committees?
Can I respond? So the intent, and this was in discussion with Dr. Finney and Mr. Lipman, that this is a benefit that's obviously, well, I imagine in perpetuity, and that $1,500 cap over the years, decades, will need to be increased, more likely than not. And rather than restricting the state to have to come back and get new legislation, this was decided as the most efficient way to allow them to come and get that cap adjusted, rather than having to go back to the legislature and rewriting the law, so to speak, and yet still providing some control over the changes over time. And I would defer to them to speak directly to that if that would help.
Well, thank you. That seems to make perfect sense to me, and I'm really in agreement with all the changes that have been made. I think they do not change the substantively the benefit in any way, and I think in many ways they make improvements in clarifying things. Thank you.
And based on your work with HHS, are you comfortable saying whether or not you think the policy committee would be fine with this?
I think they would be absolutely fine with it.
All right. Does that address your questions?
Yes, and thank
Okay.
you.
Mr.
All right.
Chair,
Yes.
I also did speak with the chairman of HHS and,
Yeah.
did go over the benefit with him as well.
Okay.
The amendment with him.
Okay. Well, great. Thank you. So the other, I would have felt comfortable getting Division 3 sort of on the record today on what the House has done. But I have to tell you that I just today became aware for the first time of Senate Bill 422 FN. And I'm told that this is extremely similar to what we've done, but they've got a different funding source other than general funds. And because I've not read this, could you give us your view on what SB 422 does that this bill does not do?
In terms of the, has the same $1,500 cap. Where it would differ is they do not limit the denture benefit, and they do not include the cost sharing that's included in Representative Earth's amendment or other amendments that the committee has considered. Those, I think, would be the key differences. In terms of the range of benefits other than denture, I think they line up pretty
It's the same.
Those again, changes.
So the differences would be that there's no limitation on denture to a specific population, and there is not the cost sharing. The similarity is that they both have the 50 to be solidified on what the cost of coverage would be.
All right. So we did put this on HB 103 on the calendar for us to discuss on the 1st of March. I think we've go ahead.
Just one other point in terms of what the difference in the cost estimate. So the state share under Representative Earth and HB 103 has been 6.91 million on an annual basis. If I'm remembering correctly, it's 7.45 million under the Senate version.
Again, if you have those written down, it'd be great for us to see the difference between the Senate and House estimates. Did you get them?
4.175 million.
All right. So, Mr. Ripple, did you want to make a comment?
he whispered in my ear. One other point I should have made is the financing mechanism contemplates using the settlement
Right.
proceeds from Centene settlement that the state had, minus an amount that's necessary to sort of complete a portion of the what was the damages in terms of paying back to the federal government their share. So it's about roughly around 18 million of the 21 million, or 18.5 million of the 21 million would be used to help fund the dental benefit over time.
Thank you. So with that, I think what I'd like to do, and this is open to some discussion, is I'm favorably leaning towards accepting the IRF amendment. The Senate bill, and of course we're going to vote on all this and discuss it, but I'm just letting you know where I'm at. I'm favorable towards the IRF amendment. On the Senate bill, on page 2, starting at line 32, and I'll be giving this to you, there's a section on the settlement fund that was just referenced, and so what I would do, left to my own devices, I think, is to take 103 and append into it another amendment, maybe amend the IRF amendment. I don't know how to do this. Mr. Ripple can help us with this. Is to take the settlement language and include it in HB 103. I am very much opposed to expanding the benefit beyond what 103 has done. I think we've spent a lot of time on it, more time than the Senate probably has. So I like the sculpting of. Sorry, it's my housekeeper. She's important, but not that important. I just lost my train of thought though. So I want to. I think I want to keep 103 as the shell. I like the IRF amendment, and I want to take the settlement money and put that into 103, and that's what I'd like to take to the Finance Committee for acceptance. And I think we can do that in something like an executive session of Division 3 on the 1st of March, and with your help, Mr. Ripple, of course. So that's where I'm coming from. What are your thoughts?
I would concur.
Representative Weiler says he concurs. What do you think, Representative Irv?
It makes sense to me as well, yes.
Okay, Representative Bean, I see you shaking your head. Representative Long, do you have an opinion on this? I know that you're sitting in today for. Okay, Representative Wallner.
I'm good. I think it sounds
Oh,
like a
okay, you're good
plan.
with that? That approach? Okay. And so Representative Rogers, you're okay with that? Okay. So, and there's no reason, or is there a reason for the department to disagree with this approach?
No, there's not.
Okay, Representative Shapiro?
I don't really understand the implications of where the funding comes from, but it's, if the department thinks that that's a good result, it's fine with me.
I think it actually helps the likelihood of passing the bill because there's an identified source of funds so that we're not taking it out of general funds in the near term. So we've got a 2, 3, 4 year run rate that is supported.
I would definitely support it.
Yeah. Okay. Any final words of wisdom for us?
Just appreciation and thanks for working with us.
Okay. All right. And
For your help.
with that, I'm going to close today's hearing on HB 103, and we will reconvene on it on the 1st of March. We're going to bring in another amendment that respects Representative Irf and respects the Senate's source of funding. So, all right. Mr. Ripple, I think on the calendar, did I put that we would start 1677 at 11 a.m.? I may have done that, or did I just sequence them? Okay.
You just said you'd take an hour.
So Yeah, so let's go ahead and take a 5-minute recess. The Attorney General and Attorney Ramsey are in the hallway, I think, and then we'll start with Mr. Vincenzio. Vincenanzo. I've been told that if I try to sound Italian, that I might be able to pull it off. But all right, thank you. It being well after the 5-minute recess, we're going to go ahead and open the hearing on HB 1677. And consistent with the promise last hearing, we're going to hear first from the victims' rights advocates today. And I think we have two that want to speak. I understand we also have a member in the citizen in the audience that wants to talk about right to know. So we'll invite her up maybe third, and then we'll bring the Attorney General and Senior Attorney for the department over to sort of bat cleanup. So that's where I'm at. Welcome. Did you get a chance to sign in?
I didn't, but I also have a question.
All
I
right.
had heard a week ago that we may also have somebody here to just explain what a structured settlement is. Are we going to be able to hear from that person today?
Is that what Mr. Early's doing?
Yes.
Yeah. So yes.
Thank you.
Okay. And since we don't have to operate one as a committee, I would like that to be a succinct training session for us so that we get the highlights. All right. So with that, is Mr. Vincenzo? Vincenzo.
Excuse me, Mr. Chairman.
Yes.
Could you ask the AG to hand out the amended version so that we all...
Would you like to do that now?
Yeah,
Okay.
that way it...
All right. And so since I'm asking you to do some work, also if you'd like to use the table as you're writing your notes, you're welcome to find a seat. Okay. All right. We'll take your paperwork. Oh, I think I was supposed to hand these out. I don't know how I got so many of them.
The one that was sent out last night was not numbered. You know, the sides weren't numbered. This one is. And so... Okay, so it just... It's the same, but yeah. But you have to pronounce the one from here.
Okay, well, while we're passing that out, I'll do some administrative notes for the clerk and for the public. We had asked for a written testimony. I think we got that from you, and we've got some written testimony also from Mr. Early. And so the clerk will lean heavily on those. If you would just take any sort of supplemental notes so we can keep track of what documents we received. And then when the Attorney General starts walking us through the change document, we'll go in sequence like we did last time. And rather than having you record, Mr. Clerk, all the things being said, if you'll just sort of time stamp when we're talking about particular things so that the public can use it as a table of contents or a reference so they can actually listen quickly to the part of the testimony they want to hear. Is that, do you understand? Because that's different than normal.
Yeah, no, we said it last time, just to get
Okay. All right. So it seems like the rustling is done, and so you're welcome to begin.
There we go. Okay, thank you. Dave Vicinanzo, for approximately 500 child victims of the YDC. Thank you again for the opportunity. I really appreciate you letting me go first this time. I'm going to still try to keep it brief and to the point. I want to preface it by saying I only received the latest draft from the AG's office late yesterday, and Jim Hatem and I, my partner, worked late last night putting together this summary testimony. But I read it again this morning, and I realized, I have more to say, but I'm going to ask you if I can have an opportunity in the next day or two to amend this or edit it or put it in another form. So there may be a few things that I want to add to it.
I think that's fine. Let me go over the timeline to make sure I'm clear with my chairman.
Okay.
Madam Chair, what I think we're asked to do, Division 3 and Division 1, is to try to exit from this committee with a recommendation, a document that we give a recommendation on, so that the full Finance Committee can get it shortly after the 1st of March, and then we're ready as a full committee to vote on it. Is that the timeline?
And I guess we might also say that we've got another hearing on, or work session on the 1st.
Right, I've got that. We're going to meet again on the 1st of March, but if our expectation of the deliverable that day is a vote on a final document as a subcommittee, I'm just thinking that we need to send the full Finance Committee a document with our recommendation.
Yes, you do, but it probably won't occur on the 1st.
All right.
Okay.
I truly hope we can try to do that, just to keep from log jamming, but thank you for your flexibility.
I understand.
Well, we have a snowstorm coming tomorrow, but nonetheless, we'll be talking by phone, my partners and I. And one of the things we've not been able to do is since last night, talk to any of our clients. And that's, we can only talk to a few of them, not 500. But
So I don't think I answered your question. Your question was, do you have some supplemental time to revise and extend your remarks? And you do.
okay.
I would
appreciate
just ask you that you continue to work with the AG's office so that they know what's going on, because they're helping us prepare the document that we're going to talk about on 1 March.
Okay, good. So,
All right.
well, I mentioned Friday because I think maybe by the weekend we'll have that supplement, or by Monday, so it's here in advance of the Tuesday session. Is that fair? Okay, thank you. With respect to the latest draft from the AG, last time I mentioned the 3 central and essential points that we considered necessary to a victim-friendly resolution of all this litigation. And the first was that it include all the victims, not just a subset. And we don't want to discriminate against victims based on the type of harm, rather than just the fact that they were harmed. That's one. The other is the independence of the administrator. And the third was that we asked that victims not be required to, as a price of admission to the process, be required to waive or give up their judicial rights. It seems to me that we've made significant progress on 2 of those in the latest draft. The first is that I'll address is the issue, or I'm actually not going to address, is the issue of moving the selection of the administrator from John Formella, from the AG, and being selected by the judiciary, by the Supreme Court. I have to admit, it's not something I ever had thought of. When I saw it last night, I said, well, it's not the AG. That is progress for our clients, and maybe that will be more palatable to them. But it's still too new, and I really haven't thought through the consequences and the ramifications. I mean, a couple of quick things. One is that by making it a full-time judicial employee, I'm wondering if we aren't limiting the pool of talent from which we can draw. I mean, I would view the pool of talent to be people who are actively doing mediations for a living and arbitrations for a living, and are very good at it and have done things that are similar to this. I don't know if they're willing or would be required to give up that practice in order to take this job. I don't know. Maybe we have part-time circuit judges. Maybe you could maintain your mediation practice over here and still go to work for the state. I don't know if it's possible, but that'll be something that I'll note in my comments in the next few days. The other is that we have to talk to our clients. I mean, our clients, the measure of success for this program or this process is going to be on how many of the 500 actually use it. And I've talked to you several times about the level of trust, which is actually very low among our clients. They view the state as their abuser, the state as having harmed them, not helped them. And oftentimes that harm began with a judge, usually at the circuit court, the family court level. A kid who may be being abused at home, next thing you know, he's acting out at school, smoking cigarettes, and then he's skipping school, and his stepfather's only apparent approach to parenting is beating him. So he's being beaten, but he's not telling anybody that. And next thing you know, he's skipping school again, and he's scoring weed. And then he goes back to the judge, and the judge puts him in YDC. Meanwhile, the judge knows nothing about the abuse at home. He knows nothing about all the other problems the kid has. And the kid's sitting there at 14 or 15 thinking, boy, the judge has wrecked my life. I'm separated from my family, and I'm in this terrible place. So a lot of our folks are, when they hear about the judiciary, that's their experience. For me, Gordon McDonald, I have tremendous respect for Gordon as the chief judge. I've mentioned that before. He's my partner for 17 years, a person of great integrity. I would trust Gordon myself, but it's up to our clients to make that call. And I need more time to really think it through and opine on it, and I will in the next few days.
All right, I appreciate where you are in your thought process and your communication process. We just need real clarity, because we've gone through we've gone through maybe 3 scenarios of how we're going to appoint this administrator. And so far, you've had concerns about all 3 of
Yes.
the methods. So we need you to know I would like to know what you're for. What you want us
Yeah.
to do.
On
And
that-
we don't
on
have
the-
to
on
do
the
that
issue-
today because you said you need to think about it.
I do.
Okay, so think about it, but we're just going to need clarity.
Yes, I'll try. I'll do it give you as much clarity as I can.
All right,
I
thank you,
just
sir.
can't today on the fund administrator. It's too new.
Right.
Okay. I do have much more clear ideas on the first point, though, which is the scope. The initial draft said only victims of sexual assault, and now this draft is broadening that to victims of physical assault as well as sexual. What we proposed instead is really the definition of child abuse that DCYF uses in its manual, which is broader than physical and sexual abuse, but also includes emotional abuse, usually in the form of unlawful confinement, solitary for weeks or months at a time of a 15-year-old. So that's what we propose. I think it's progress, but we really want the solitary confinement piece to be included. I have submitted to the committee a fair amount of studies and expert opinions about the harm to a child of this form of emotional abuse is probably the most significant harm. It may be counterintuitive, but the experts tell us that is true, and that if you put a kid in solitary for 2-3 weeks, 2-3 months, that does more harm to them than an actual beating, and it does more harm than a sexual abuse. That's what the experts tell us. I don't think it should be excluded, and so that would be our pitch on that one, and I've provided some annotation here for a summary of our argument. We don't want to discriminate against the various types of victims.
Representative Umberger?
Thank you. In your discussions with your clients, do you have an idea as to how many were put in solitary confinement at YDC and for how long?
Yes, we do have some idea. I can't put a number on it, but I will tell you the number is very, very high of kids who were put into solitary confinement. The numbers, when we're talking weeks and months at a time, those numbers are obviously smaller, but they are still very significant. And I view it as something where, kind of like a lot of, some parents who are tired, they put their kids in front of the TV. I think at times the way you handled a kid who was acting out or was oppositional, had trauma and problems, to lock them in a cell. And I think that was a form of babysitting, and it did tremendous harm to a lot of these kids.
Thank you.
I will add, though, that I do not think that the number of kids who only suffered solitary confinement, I don't think that number is large. It's almost always accompanied by physical or sexual abuse. So the number is not great that only suffered solitary. So we're not talking about a large number being excluded here the way the bill is written. But I don't want to exclude anybody. I'm not going to give up on those folks. And I don't think the state should either. I think the state should recognize that that is a very substantial and significant form of harm and a form of negligence on the part of the people that ran the YDC. And it should be recognized. They shouldn't be. It doesn't mean their lawsuits aren't going away anyway. So state's going to still have to deal with it. It's just that why not deal it in this expedited and controlled and more victim-friendly process?
Do you think, did you have a follow-up? No. Do you think you can provide input on the definition that you would like to see included so that the solitary confinement
It's
is?
in our notes.
Okay, and then, because I've not read through all of this, I'd like to ask you if there's a distinction that is made in the definition between solitary confinement for an hour, for a day, for a week. You know, I would think that there's kind of an exponential curve
Yes.
to the damage being done based on the amount of time.
Agreed.
So is that
Well,
that sensitivity to the amount of time?
I don't think that this bill can get to that level of granularity. I just don't. I think that's for the guidelines process that the bill proposes. And that is, I think, going to require some deference to the AG and to the claimant's attorneys and to the administrator to figure out those terms. The people who are expert in this and do it a lot. For instance, now, YDC's current rules, only since 2020, say that you can't put a kid in for more than 15 minutes into solitary. 15 minutes. Now, I'm not even talking hours. I'm talking days and then weeks and then months. But that's something that can be baked into those guidelines when we actually get in a room and say, well, what do we understand to be inappropriate? I mean, there are times, of course, I think they're rare when it might be necessary for the security of the child or the security of the institution, of other kids. It's possible. I'm not discounting that possibility, but that's not what we're talking here. We're talking about it being almost ubiquitous and routine and done for punishment or just convenience of the facility, or a way of breaking their will. And in my view, that is not a humane way to treat a child. You don't break a child's will by locking them up for a month at a time in their underwear. Just don't do that.
Representative Emmert?
Thank you. Mr. Chair, are we dealing with records with this, or are we dealing with testimony? I mean, do we have records that go back to show the period of time somebody was in solitary confinement?
I have not seen the state's records because they haven't shared them with us. And as far as I understand, Jen Ramsey, who is managing the civil side for the state, may not have seen them either because they are possibly tied up in the criminal investigation. And there's a separation between the criminal and the civil. But what I do have is I have a lot of our clients' records, which are from YDC. And of course, I have my clients' testimony. And they're telling me, and at a certain level of consistency between these folks who don't know each other, but are saying this is the same. It sounds very similar, over time. That this practice existed, and that it was a way of managing the facility without really caring for the kids, and locking them up and making them go to the bathroom in their cells because there's no toilets in the cells. And not let them out to go to the bathroom. And the stories are horrific. And these are people that don't know each other, and they all saying what ends up being kind of common themes. So I have access to all the witnesses, which the state doesn't. I don't know exactly how comprehensive or granular the records kept by YDC were because we haven't been given access to them yet.
Do you want to go on with your?
Yes. I'm still on page 1 of my summary, and I'm looking at page 4, line 3. Just again, this is just from last night. The state is now talking about the possibility of including physical abuse, but it says that has interposed a cap of $150,000 on any case of physical abuse. As far as I know, that number was pulled from the ether, and it's not tethered to anything real. I don't think the state actually knows what the damages are yet. I don't think the state hasn't heard from the witnesses yet. The state doesn't really know what happened, so I don't know how it could be anything other than arbitrary to pick a number like 150,000. You know, you received my letter yesterday. There may well be claims that are worth less than 150,000 or 150,000, but there's also plenty that are worth more than that. And I don't know why a person would participate if they felt that the process is going to lowball them, you know, on something that is worth more.
Are you recommending the state go without a ceiling?
Well, the ceilings.
Or do you have a
Yeah.
different arbitrary number to pick?
No, I don't have an arbitrary number, but a different number. The number we propose is the one the legislature has already enacted. There's two numbers. One is for individual events, and the other is for aggregate individual events. And if I remember correctly, I think the statutory number is 325 per incident maximum. Of course, it could be 0 too, but the max I think is 325. And the aggregate total for an individual, say somebody has been beaten 15 times or put in solitary for a year or whatever, the aggregate is actually defined at RSA 14:35B. It's actually a formula, so I can't give you a specific number because it tends to vary every year, but it's tethered to the general fund revenues. It's a tiny percentage of those revenues, but it is it provides a ready-made cap that the legislature has already approved for aggregate per individual cases. I don't know why would we differ from what the legislature has already made law? I think that's really what the cap ought to be.
Yeah, I think you've raised a good point.
Okay.
Do you have another good point?
I hope so. I have to tell, of all the things that we are most concerned about, it is broadening the scope so all the victims are included. That's the most important thing. I've mentioned the independence of the administrator and the interesting idea of reposing it with the responsibility with the judicial branch. I admit I had never thought of that before, and I'm going to have to think about it for a few more days, and I'll get back to you on that.
So to append to that, though, if you think about it and you don't like that idea, I would just ask you to come up with
something
with a
else.
specific
Yeah.
idea.
I will. Okay. Thank you. I'm on page 3 of my summary, but I think I've already covered it, which is the issue of the caps. I don't think these arbitrary numbers make sense. I've already said, why not just go with what the legislature has already made law? That's what would apply in the court. Why should it apply any differently here? I just don't see the reason. I'm on page 4 of my summary. This is our third major concern, and that is that that a victim who wants to bypass the judicial remedy or wants to at least submit a claim and try to settle the case without having to go through the full gamut of judicial process, why should they have to, as a price of admission, give up their judicial claim? We don't want to force victims to do that. Now, this issue could be influenced depending on whether there is sufficient level of trust in the administrator. We don't have that yet, and a sufficient level in the guidelines that will be developed. We don't have that yet. And if there are no arbitrary caps, we don't have that yet either. But if all of those things fell into place, maybe I could recommend and persuade my clients to say, you know, it's worth the risk to you because you're pretty certain, we have a pretty good idea of what the range is where you're going to fall. And when you go to the administrator, we have a pretty good idea because the guidelines tell us, and we trust the administrator, and we're confident in his or her independence, and there are no arbitrary caps. Or the only arbitrary caps are what the legislature's already allowed, and those would be sufficient for your purposes in this process. At that point, we might be able to say, sure, it's worth the risk of giving up your only leverage and entering the process. But that's a lot of conditions that we don't have yet. But right now, it's too risky. I wouldn't advise them to do it. because it could be a trap. They end up in the process, and the AG makes a low ball offer. The administrator maybe agrees with it, maybe changes a little bit, but it is a fraction of what the person feels they're owed, and maybe their lawyers agree with them, and then you're stuck. You gave up your rights. You're stuck with what they give you, and I don't think that they should be required to do that as a condition of participation. What I would propose is something a little bit different. And I have to admit that I am not totally clear what the draft last night actually means. It does seem to me that maybe it's inconsistent between page 5 and page 7. Maybe Jen will be able to prove me wrong that it's not inconsistent, but I couldn't figure it out. I wasn't sure what it meant. But maybe what the point at which the judicial rights are waived is when the individual finds out what the proposed award is from the administrator, and they can say, okay, I'll take it now, or I reject it, I'm going to go back to litigation. I think at that point, yes, that's fair to make them make a choice. But to make them make a choice before they have any idea what they're going to get, I don't think that's fair, and I don't think many people are going to agree with that.
So I
Agree
want to
do it.
repeat that just to make sure I'm tracking.
Okay.
What I think I just heard you say is that you would not want your claimant to waive rights to another process
Yeah.
until they've entered this process, but they would have to exercise their option before being told what the monetary award would be.
That's how it is now, yes.
And that's what you could support.
No, that's the way it reads now. No, what I could support is the administrator lets them know, this is where I'm coming down. I think your case is worth 150,000, and now you know, and at that point you make a choice. I take it or I don't. And
All
the
right.
administrator goes. If he takes it, the administrator goes forward, finishes the process, issues a written award, and then you're done, and you've waived all your judicial rights. You give the state a release, and it's done.
Thank you for the clarification. Would you take a question from Representative Umberger?
Of course.
Yeah, thank you. Thank you, Mr. Chairman. I think line 3 says they've inserted the word simultaneously, which means if you enter the process, you can't go to court at the same time. I mean,
Yeah.
that's
I read that way too
Okay,
at first,
so-
except then I read page 7 and it seems to contradict that.
well, I guess that one of the things that is concerning me is that hopefully resolution will occur before it goes to the administrator. In other words, I'm not looking for every case to have to go forward to the administrator. And, well, that's not mine. Thank you. That's okay. Yeah. And so anyhow, that's how I read that, is that we're not suggesting that you can't decide to go to court.
Yeah.
But you just can't do both at the same time.
Well,
And that's-
I see that's a difference, and
You
if
know.
that's the case, well, I think Jen will probably clarify it. I read it that way in page 5, but then I went to page 7, and it says, by requesting a resolution proceeding, a claimant fully waives his or her right to seek other relief in any other forum, including the judiciary. So I think I don't know if that means at the time of the claim or the time that you go to the administrator, but in any event, it's well before you know what you're going to get. Now, again, this could be possibly affected by a couple of other contingencies. One is, do we trust the administrator? Second, do we trust the matrix or the guidelines? And 3, are there no arbitrary caps? If those 3 things come together and we trust all those 3, we might be more willing to waive in advance because we have a pretty good idea we're going to get a fair shake. But right now, I don't think that we can say that. I don't think we have that level of confidence, and I wouldn't be malpractice for me to recommend to my clients, give up your only leverage before you have any idea what you're going to get. I don't think they'd be crazy to listen to me, and I would be wrong to give them that advice. So I would urge the committee to consider allowing the award to be communicated, maybe just verbally, to the claimant, and then give him or her a chance at that point to say, yes, I accept, or no, I don't, and please, or yes, I accept, please go forward, no, I don't, I'm going back to court.
So, Representative Umberger, do you have a follow-up? No?
No, I'll wait.
Okay. And I'm
Thank
going to
you.
go to Representative Lynn in just a second, but I just want to make sure I'm understanding your concern about the arbitrary limit. When the guidelines are issued, there will be ranges included in them, and as I understand the ranges, it'll have a ceiling and a floor. I did the hand wrong, but you're not opposed to having a closed-ended range.
No, I'm not. And it could be a range, or it could even be just a number that is an estimate. But I think the devil's in the details. If it's a range, I think that's fairly standard. We'd see that fairly often, a range. But we have no idea how those guidelines are actually going to come out. Whether they're going to have to be agreed upon, and then and I actually do have a point on that, of the process of getting there. But again, if we had confidence in the guidelines and that the ranges were fair and sufficient and there were no arbitrary caps, then it's possible we would be more inclined to or able to recommend to our clients that they waive their rights in advance before they know what the award's going to be. But
Okay,
that's-
so I'll go to Representative Lynn. I just wanted to say that I'm still a little confused on your concern about arbitrary caps, because if there's a ceiling and a range, it's effectively capped.
Well, if there's other language in here that says the cap on any violent act or any violence is 150,000, and it's a $450,000 case, that's the range has got to obviously be going to be between 120 and 150, because 150 is the max. So that's an arbitrarily low and standard. If those caps are removed and they just become the statutory caps that already exist, well, that gives us a lot more room to play with, and those ranges can be set at different levels.
Thank you for your patience. I think I understand what you mean when you say arbitrary cap. Representative Lynn?
Yeah, thank you, Mr. Chairman. Mr. Vicinanzo, I guess the thing that I'm not clear on is this. I think I understand your position that you think that your clients should be able to go through the process, including sort of not coming to an agreement between your clients through their attorneys and the Attorney General's office, going to the administrator, having the administrator issue a decision saying, I would award your client X, and then still being free to go to court. Is that?
Well, I don't want to put the administrator to too much work, having to write an opinion or a decision.
No, I understand, but
at some point, and the way this is typical in mediation, the mediator will say, "Here's where I'm coming out. I've heard him, I've heard you, and I've considered all the factors, and I think that 150 is a fair amount."
Sure, no, I understand that,
Yeah.
but I guess what I'm really saying is, you're free. If we develop the system that way, it seems to me it's not really very much different than what the law is right now. You and the Attorney General could sit down right now
Yeah.
and come to and try to work out a settlement, and if you weren't happy with it, you could go to court. So
Right.
I guess what I'm kind of wondering, if we were going to allow that, my sense is, what do we need this legislation for? Why don't you just,
Well, you're right.
why don't you
in
and the
some
Attorney
ways.
General just sit
Sure.
down and work it
Well,
out?
and we can always do that even with this legislation.
Right.
And our Judge Schulman is already after us to sit down for mediation now, to push us on that. But that's why we want this process to be as much like the mediation that we're familiar with. Because otherwise, our clients would probably choose that over this. And I think this is could be a better process and could expedite things a lot and be better for the state. But I think it's unfair to ask somebody who all they have is the judicial claim, and ask them to give up in advance that one piece of leverage that they have, the only power they have, before they have some idea, pretty good idea, what their case is going to be worth with the administrator. I just don't think that people are going to do it, I don't think that I can recommend it. Now, again, if the guidelines are well developed and we agree to the guidelines and they are sufficient and the ranges are adequate, and we trust the administrator, that could be different. That might make it different. But those are contingencies that have not been decided yet. You know, and that at that point we might be able to advise it's worth taking the risk, go through the process because you're pretty sure to get something that's pretty fair. But right now we can't say that, you know. So I also, kind of relatedly, and this is going back to those guidelines, and one of the things that the draft last night does is it kind of seems like an awfully elaborate process to come up with these guidelines. And then it's not clear that the guidelines are mandatory or advisory, or are they presumptively what the range would be for a particular act or group of acts? It's not really clear. And I also note the guidelines have to be developed before the administrator is picked. I kind of feel like it would be wiser to do it the other way, the reverse, which is pick the administrator, and then the AG and the council have to sit down and work on the guidelines. But they have the benefit of input from a neutral third party, the administrator, who is also presumably a wise man or woman who's knowledgeable in this area, and will help them. Because I could see these guidelines being very difficult to come up with. And the AG will come at it, and they're going to lowball as much as they can, and we're going to try to get as much as we can for our clients, because that's what our civilized society, that's the set of incentives that we've set up, because they have no other friends except us. So we're there to fight for them, and that's what we're doing. And the AG, meanwhile, has a duty to get the best deal for the state. So you've got the two partisans button heads. Wouldn't it be good to have an administrator in the middle to kind of, who doesn't have a dog in the fight, to help them get to agreement on those guidelines? Because I could see that being a point at which this whole process could break down. The other point, I think, where it could break down is bringing the guidelines back to the Finance Committee. I think that's going to be a really tough thing. I think at some point the legislature just got to trust the experts and the parties to some degree, based on expertise. Because what's it going to look like if it comes back to the Finance Committee? You're going to be talking about very explicit, graphic, physical, sexual acts or abusive acts, and trying to put a number on them and subject it to a public debate. And what is this worth and what is that worth? And I don't know. I see that as being very awkward, very unwieldy, and a decision point that is another opportunity for this whole process to break down. So I feel that the way it's proposed now is too complex, too many junctures at which it can fail. I wish it could be streamlined. The way we would do it, and the way we would do it in front of Judge Schulman, is we'd sit down and we'd have to argue it out, and the judge would probably act as the judge probably wouldn't do it. Judge would appoint a mediator, and the mediator would be a neutral without a dog in the fight and help us get to agreement and see the weaknesses in our case or the strengths in the other side's case and get to an agreement that way. But this has so many different layers of approval and discussion, and I just see it failing if it remains the way it is.
Okay, I'm going to go to Representative Weiler here in just a moment, but I want to comment that we did talk about the Finance Committee reviewing these last session.
Yes.
And it's not our money.
Yeah.
It's the taxpayers' money.
Yeah.
And so I think what the thought was let's do this in a way in which it's transparent to the public,
Yes.
since they're the ones writing the check ultimately.
Absolutely.
So Representative Weiler?
This is a finance committee. We make financial decisions. We expect results. We have an audit division that we task with bringing us the results. You're bringing us forth something that has no results except for you. Does it cure the problem? Does it help the victims? Are they still going to be PTSD, post-traumatic stress, and so on? Nothing of that will change. And how do you assess which one is worse off? Are you going to do a psychoanalysis of each victim to find out how damaged each one is? Is that included? Are you going to have group therapy sessions? None of that's proposed. You're just looking for money. What does the money do? Nothing. As far as I'm concerned, it's a waste. All we're trying to do is save time for the Attorney General and the courts by offering, and you're just trying to expand it. This is ridiculous. To say, oh, someone's punished by solitary confinement. What precedent does that set? Everyone in the prison can come in here and sue us because They suffered from solitary
Rep-
confinement. I
Representative
refuse to
Weiler.
widen this.
I,
Thank you, Mr. Chair.
thank you. I just want to say that in these hearings, our goal is to collect information that we can talk and
Sorry.
think about later. And we don't want to berate any of the witnesses. And I think we got a little close. So thank you.
Can I speak, Mr. Chair?
Yeah,
Just
oh,
that
sure.
I appreciate the comments from Representative Weiler. Look, I could retire tomorrow. I don't need to be doing this. I figure I got 10 good years left. I want to do this. I feel so passionately about what happened to these kids, and I'm not going to be deterred. But I appreciate your comments, but I do think they kind of illustrate my point earlier, which is, everybody's got an opinion, and I think if we don't streamline the process, it's going to fall apart. And I don't think it should fall apart. I think my first goal, of course, is protecting the victims and getting them some form of justice. And you're right that money never is sufficient. It never is. Of course it's not. But we can't undo the past. The only thing we can do is what the civil system does, and it's a recognition of, in some way, of the harm, and it's some form of an apology to those kids who suffered at the hands of the state for so many years. So I appreciate your comments, but I do think it kind of illustrates if it's an open field for conversation and discussion and debate, I'm not sure it's ever going to get done. There has to be some room for deference to folks who actually do this and who actually talk to the victims and who have expertise in the area. I'm not sure, and I try to come up with a more concrete proposal than those abstract notions I'm talking about right now, but I feel like I want to make that point. If you put too many junctures at which the process can break down, then it will break down.
All right. I don't want to rush you. Do you think you're done with your main points?
I had one more, and I don't know that it's a main one, but it's on page 5 of our summary. And this is, again, I'm not entirely clear about what the AG is proposing here. Page 7, line 34. The administrator's decision regarding the claim shall be final and non-appealable. And then certain provisions of RSA 542 will not apply. I think the concern here is the AG doesn't want an appeal after the administrator makes a decision, and I agree with that. That's fine with us. Except, I mean, obviously, if there's an appeal based on a plain error, a mistake, mathematical mistake, something like that, or I still think you should have access to the courts to correct it if there is such a problem. I don't anticipate there will be. But our concern here is because we are putting together kind of a form of arbitration, is that we want the award of an administrator to be a final and enforceable judgment. And I think that's the intention here, but I have to say that I feel like the language isn't that clear. And we've gone back and forth with the AG several times, and I don't know if we're talking past each other or maybe we're not understanding, but our goal here is that once you have waived your judicial rights and you've got the administrator's award, that it is enforceable. And typically, to do that, you have to go to court and have the court bless it under the arbitration statute and say, yep, it is now a final judgment, I've reviewed it, and it's now enforceable. I don't know if we have to do that, but I want to make sure it's final and enforceable, that's all. That's our only concern. How we get there, I'm open to suggestions, but I did make the comments in the margin, which is our attempt, at least, to provide some language that would help us.
So I'm hoping that when the AG's office comes up to the table that they can address that issue. All right.
Yes.
What else you got for us?
Those are the main points that I had, and I appreciate the opportunity to comment further on the issue of the appointment of the administrator in the next few days, and I will do so. But those are the points. I mean, it's not discriminating against any of the victims, not making them give up their rights unduly without having some idea what they're going to get, and then the independence of the administrator.
All right. Thank you very much for your testimony. We'll invite Mr. Early up. We have so Mr. Early, come on up, and before you launch into the lesson, would you tell us why you think it's important for us to know what a structured settlement is? So before we get into what it is, let's talk about why you think it's important for us to understand it.
Sure. Thank you, Mr. Chairman, and
Okay,
thank you, representatives. I appreciate the time.
Mr. Chairman, two questions. One, I've requested of the attorney that he comes in with copies of your testimony for everybody on the committee, please. Because I know that it's been, there were a lot of pages involved with your last presentation for your testimony. So I would appreciate copies of your testimony, written testimony, for all members of the committee.
Excuse me, Robert, do you know they're right there on the table? I've got it here, that he did have them here for us today, and everything he referenced is over there on the table.
Okay, I apologize, sorry, thank you. Secondly, for the clerk, could you repeat your name and for the record? Yes, yes.
My name is Peter Early, E-A-R-L-Y.
Thank you.
Yep, I live in Windham, New Hampshire. I work for Ringler Associates, which is the nation's largest structured settlement provider. And to answer your question, Mr. Chairman, I'm here to speak on structured settlements. I believe the most recent version of legislation that I was able to look at last night includes reference to structured settlements. I'm here today to talk a little bit about what they are, how the parties involved operate when a structured settlement is utilized, and answer any questions that this committee may have. So for those of you who are not familiar with the structured settlement, it is basically it's an alternative to a lump sum where a claimant as part of an injury settlement can receive their proceeds in fixed and determinate tax-free guaranteed payments as opposed to a lump sum. I have worked with injury victims, insurance companies, and personal injury attorneys throughout New Hampshire and New England for most of my career. But our industry has also been involved in similar mass tort legislations like we're talking about today. We were recently very involved in the Michigan State Sex Abuse Victims Fund. We've also been involved in the Station Fire Victims Fund, the 9/11 Victims Compensation Fund, the Boston Archdiocese Fund, to name a few. So we're familiar with this form of fund as well. A structured settlement exists primarily for someone who is unwilling or wants to have their payments spread out over time in a guaranteed tax-free manner, and that's the way that structures operate, and they are often very well utilized in the types of victims we're talking about with this legislation. My services, as somebody who works with the attorneys, the victims, and often the insurers, or in this case the state, is to customize those plans, educate the parties about what the process is. My services come at no cost. The entire award that goes into a structured settlement is invested in the annuity, and importantly, the state, which in this case would be purchasing the annuity on the victim's behalf, also pays no fees and has no ongoing obligation by a mechanism what's called a qualified assignment. I have materials to explain that a little bit further. The state has no ongoing obligation if a structured settlement is entered into. They are released just as if they are issuing a lump sum payment, and the obligation to make those future periodic payments is transferred to the annuity issuer. All of the annuity issuers that we work with in the structured settlement industry are A or rated better companies by AM Best. These are life insurance companies that you are most likely familiar with, companies like MetLife, Pacific Life, Mutual of Omaha, USAA. My purpose here today is, especially that now that there is reference to structured settlements included in the legislation as an option for a claimant to elect, should they wish to go that route, is to answer any questions that you may have, and I'm happy to do that now.
I have a question for you. Have you seen the document that we received today called HB 1677, Second Recommended Amendment by AG?
I believe so, yes. I believe I received that last night.
Okay. And Are you satisfied that the language in this document is appropriate?
Yes, I think that it provides the option for somebody, if they wish to go that route, to elect to do so. And importantly, the language that's in there also protects the state. There's a reference to a qualified assignment under Section 130 of the tax code, and from the state's perspective, that's what I wanted to make sure that was in there as well, to make sure that that obligation is transferred away from the state should somebody receiving an award from the fund elect to do a structured settlement.
Okay, so I'm viewing you as a friendly witness that you think that what the AG's doing is perfectly appropriate and the right words are in this draft.
I think that the language specific to structured settlements that's in the most recent version is appropriate from my chair as a structured settlement expert, yes.
Well, thank you for that. Are there any questions from the committee? Representative Weiler?
What savings do you offer us, or do we make this payment in totality up front?
It generally depends. The savings are not necessarily an aspect of it as much as the award that the administrator would issue would be the amount that is final. What the victim then has the option to do, instead of taking that lump sum and then perhaps either mismanaging it or whatever the case may be. And I think that's where there's a secondary savings in that by providing them guaranteed fixed payments as a form of income prevents premature dissipation of the funds, which could also then prevent somebody going on state services or things like that. So I think there's more of a non-quantifiable savings in that sense. But there is also as I mentioned, no obligation for the state in terms of ongoing obligation to fund those, so that the amount that the administrator would award would be the same, whether it's a structured settlement or as a lump sum.
Representative Walls?
Thank you, Mr. Chairman. Isn't it true that if somebody elects a structured settlement, it saves the state the administrative costs? Because within this, there's an option for the victim to take their payments over time, even if they don't go through you. And, or at least on the last draft I saw, I haven't seen the language in the most current draft. And if a victim elected to take their payments over time, if they elect to go through a structured settlement through one of the insurance companies, doesn't that then remove from the state all the administrative obligations on that with respect to dispensing the money, with respect to taxation, all those kinds of things?
Yes, as I read the most current form of the legislation, as I mentioned, I just got it last night, but the way that I understand it, and the Attorney General's office can correct me if I'm wrong, is that essentially there are three options. One is a lump sum, the other is for the state to fund payments, installments over, I believe it's up to a period of 10 years, or for the claimant to elect a structured settlement. Of the two that require ongoing installment or periodic payments, if the option that the state funding those payments would require the state to keep a book open to basically fund those and the accounting that goes therewith. With the structured settlement, it functions the same as if it were a lump sum. So there is a full and final release on all claims, and the state closes their obligation just as if they were issuing a lump sum. So from the state's perspective, there's no difference in accounting and ongoing obligation.
Follow up? So this, as you may or may not know, the state Supreme Court has something called Rule 40 that pertains to structured settlements with respect to minors. How does that fit into what you offer?
I'm very, very familiar with that. As a New Hampshire resident and as a structured settlement purveyor here, Rule 40 comes up on every single case that we deal with minors. And I understand that minors are not, some of the claims will be minors, not all of them will be. Rule 40 is basically a list of court-mandated annuity issuers that we have to use when minors are involved. They are not radically different than what we would use with anybody else. It's slightly more restrictive. There are about 7 or 8 annuity companies that issue structured settlements. I believe roughly 5 of them are approved under Rule 40 for minors. The only other difference with Rule 40 cases is I'm required to submit an affidavit to the court. Rule 40 has to do with the court's approval of the settlement. When a structured settlement is involved, My office will make sure that all the documents are compliant with Rule 40. I sign an affidavit for every Rule 40 case complying that the annuity meets the standards that are outlined in that rule. All of the companies that we use, and specifically the ones that are outlined in Rule 40, are major U.S. life insurers with very high ratings. And that would apply not just to minors, but to all the cases that we do.
Follow-up? Are you? Okay. I'm not seeing any other questions. Do you believe you've told us everything you think we need to know?
I believe so. The one thing I would add is just in terms of what my role is as a structured settlement consultant, beyond, I wanted to make sure I addressed what the state's obligation or lack thereof would be. But from the victim's perspective, one of the things that I do is to make sure that future needs are met. I am not a financial planner. I'm not a wealth manager. That is not my practice. The vast majority of the people that I work with are people who have never come into large sums of money at one time, and often need some assistance to make sure that their future needs are met, and that is one of the things that I do. Our industry has done several dissipation studies over the years to show what happens to somebody when they come into a large amount of money in a short period of time. And as I'm sure you're aware too, the most common form of this is with lottery winners, professional athletes, things like that. The vast majority of the people that come up in these studies, the evidence shows that the money does not last nearly as long as they expect it to. And one of the things that a structured settlement does is provide them with guaranteed income. It is an extremely simple vehicle. As I mentioned, it's an annuity with fixed and determinate payments. So the payment stream is customized, and my job is to work with the victim to customize that payment stream to meet their needs. But the payments are determinate. They are set on guaranteed dates. The amounts cannot change. They cannot be altered. They cannot be accessed early. And it is a good way to make sure that those needs are met over time without them inadvertently spending the money in ways that was not intended. So my job is to work with them to customize those payment streams, and not the entire amount has to go into a structured settlement either. One of my roles is to kind of figure out what the immediate needs are. If somebody has needs for housing or vehicles or things like that, it's a voluntary procedure where we can just kind of give them that option to provide those payments, again, at no risk or no future obligation for the funding entity.
All right. Thank you very much for your
you.
testimony. Appreciate your time
Appreciate it.
and
Thank you.
interest. And then with that, I think we've got Ms. Timmons with an interest in right to know. And then just provide your full name for the clerk.
Thank you for the chance to speak to you today. I am Anne Marie Timmons. I'm a reporter with the New Hampshire Bulletin, and I'm also here on behalf of the Legislative Affairs Committee of the New Hampshire Press Association. So I just have a few brief points. Just about
Excuse me, I didn't hear you clearly with the mask.
let me take that off.
Could you spell your name, please?
Sure. It's Anne Marie. It's one word, Annmarie. Last name is Timmons, Timmins.
And you're representing whom?
The New Hampshire Bulletin news site, and also the New Hampshire Press Association's Legislative Affairs Committee.
Okay, thank you.
You're welcome. So I just had a few brief points about the right to know law aspect of this bill. I just want to start by saying our Constitution is exceptional in that it puts in writing that there is presumed an open access to government, because that is how you hold government accountable. And I think the records in this case, which are preemptively closed under the proposed bill, are important because if I could offer the example of the Catholic Church settlement that the state engaged in many years ago now, the Attorney General decided in that case that the best course was not to take the church through the court process, but to release the records of the church's handling of abuse claims over decades, because it's important to know what happened and how it happened, and that's how you find out. And those records were released, thousands of pages, each one the names of the victims and their identifying information was redacted. And so the privacy concern was protected, but the public knew and understood how the abuse happened and what failed, how those victims were failed. So that's why I think the records here are important. I see it as similar in that this is a state agency. We know that there were many victims of the handling of this. We should know, and the public should know, what happened, what was the extent of it, what did the state know, what did the state not know, and how were those concerns handled. The AG's office did, and I appreciate this, make clear in the proposed amendment or changes that we were very clear that the settlement, the actual settlement in these cases, will be available to the public. And I do appreciate that inclusion. I know that was raised by the New Hampshire Right to Know Committee, and I am grateful that they heard that concern. That is already part of the law, so while I'm glad it's in there, I'm not sure it is necessary, and it doesn't resolve my other concerns. We do have a right to know law that I think works well, and I say that having used it for 25 years, even when I didn't get the records that I want, because it requires a balancing test. There's records I want, there's records that the agency or town doesn't want to give up. And in the way Attorney Vicinanzo mentioned that there needs to be a neutral party, that party is the court. And in that process, the court considers from a neutral perspective what we want to know, what is considered private by the state or the town, and comes to a conclusion, what should be released and how. And when there is a record that is partially confidential, it is released with that information redacted. It does not require that the whole document be redacted. It's very specific about that. And I think in this case, this is my last point, is that we are preemptively excluding from public records we don't even know yet what they exist. I'm not seeking information about how the Attorney General advises or handles the legal aspects of this case, but I do think we should know or each have an access to ask for records that show what happened in this case and how it was handled and how it wasn't handled. And that happens through the right to know law, which I think works really well.
Representative Umberger?
Yes, I guess that from one of the problems is that we are dealing with juveniles.
Mm-hmm.
And how much currently are juvenile records released when you ask for them under the right to know? I'm just not sure.
Thank you for the question. They are protected. And so in that case, I think that is the court's responsibility to look at, is there any part of that that could be released? I don't think the names should come out. I don't think the dates of birth should be released, and that's the standard now. But what did happen to this group of people who were juveniles? And that might help us understand, because in this case they were especially vulnerable. And so how did the state handle those complaints as a group, not as an individual per se, if the court felt like that shouldn't be released?
Go ahead, follow up.
So I'm just trying to come to grips with this. So you would say that you would go to court to get the information that you wanted? Or is it something that you think should be part of the process? I'm just trying to come to grips with, we know this is dealing with juveniles. Juvenile records aren't available, so.
The process, yes.
Yeah.
And it's hard to know a bit because we don't have the records yet, but the way the process works now is we, or the public, request a record. In this case, it may be the records tied to a settlement of a particular person. And we would want to know what happened generally in this case, because I think if you see these cases as they stack up, you might see a trend or a pattern. So in this case, we would ask for that record. The court may say, no, you can't have any of it because there's nothing in here that we could release without identifying the person. But in the case of the Catholic Church situation, the names of the victims who were juveniles was redacted. Their addresses at the time were redacted, but we did know how the grooming process worked. We saw letters back and forth to the church that showed we knew at the time that this child's mother complained and nothing was done. They moved that priest to another parish. So in that way, we don't know who the child is, but we know how there was a complaint raised at the time by a parent, for example, and that the church decided to handle in a way that maybe wasn't on the side of the victim in that case.
Do you have a follow-up? So Ms. Timmons, sometime I think prior to the previous hearing, the AG's office provided us with an example of the kind of settlement form that they would be completing, and what on it would be available for the public and what would be redacted. Have you seen that form?
I haven't. I had reached out, probably not in the right way, I guess, to get some more information from the Attorney General's office and to share my concerns, but didn't hear back. And I'm sure that's just a matter of it getting lost en route, but I have not seen that.
Oh, okay, so let me ask I feel like Monty Hall here. The AG's office, do you happen to have a copy of that example redacted form that we could get to Ms. Timmons? Oh, there we go.
Thank you.
That's $50 for Mike. Okay, door number 3. Do you want to take a look at that and then come back up?
Sure. Yeah, thank you. That would be great.
All right. And have you looked at this second amended draft that the AG's office has put together?
The version that's on the table, yes, and that's where I see that they did sort of respond to the request of the Right to Know group and say, we understand that the settlement, so I guess that would be these papers here, would be available, and that exists in the Right to Know law now, but I do appreciate them hearing that.
Oh, okay, so do you think at the end of the day here, you've got any specific requests for language modification?
I would like that section removed.
So just a wholesale deletion?
Yes, because I
Okay.
think we have a process. I don't think it's necessary legislation because there's a process in place that the legislature has already adopted and has left in place for many, many years.
All right, thank you for your answer. Are there other questions? Representative Walls, I see some movement. Do you have any questions? No? All right, with that, thank you very much.
If I could ask one question, do you want me to respond in writing to some concerns about that? Would that be easiest for the committee, or would you like me to come back up?
So you're welcome to do it how you wish. I'm just wanting to make sure that you've seen the example that the AG's office has already provided to the committee.
Okay.
So that any concerns that you still have can either be addressed or, so if you look at that and you want to come back up, we can do that. If you
it's
want to
o-
do it in writing, we can do it in writing.
I think I'll take choice B. I'd like to take it back to the Legislative Affairs Committee and just have a quick look at it so we're all on the same page.
Okay, now, Mike, do you need your copy back? Because we have a Xerox machine next door. So you're okay? Okay, thank you. Thank you, Ms.
Thank you.
Timmons. All right, so it is 12:16, so we're getting deep into a lunch period, and normally I would just drive through. Well, that's probably the wrong phrase. I would just continue the hearing, but I want to make sure that if there's anyone who has dietary needs where they have to eat on schedule, that we respect that. Has anybody got a timing on a? Okay. Can you do this in 45 minutes or less? I can. All right.
Depends on what questions we get.
Okay, and then that includes picking up on the things that we've heard from previous testimony today. Okay, thank you very much. Would the AG's office step forward and say your names, both of you? Representative Hatch? Oh, I blew it. I did blow it. You're right. Come on down. All right.
Thank you, Mr. Chairman. For the record, John Formella, Attorney General, and with me is Jennifer Ramsey, Senior Assistant Attorney General.
Jennifer, I have a question. Your last name, is it S-E-Y or S-A-Y?
I'm an EY, Ramsey. Thank you for asking.
Okay, thank you.
All right, so given the charge to get through this in 45 minutes, if possible, what I thought I'd do is go through a similar process as last time. We've handed out a summary of the second recommendations for amendment, so a summary change sheet. So I thought I would use that as a guide for our discussion. So I'll go through that and also look at the specific language that this summary sheet references. So these just at a high level, these changes are based on what we discussed at the last work session. They're also based on discussions we have continued to have both with Claimants Council and other organizations such as the trial lawyers and the folks who are talking about structured settlements, and others who have wanted to have input on this process. So that's kind of where these come from. They are also reflect our judgment as to what we would recommend and what we think is workable for the state, understanding that the ultimate decision is up to you all. So the first group of changes in this second amended draft are changes that are designed to go to the concerns regarding the administrator and the appointment of the administrator, the independence of the administrator, so that there can be trust in the administrator. And as was discussed earlier by Attorney Vicinanzo, what we have come up with based on our internal thinking, discussions with some members of this committee, and based on the desire to have independence, is to have the administrator be a temporary employee housed within the judicial branch. You'll see that first on page 1, lines 11 through 13, where we're just defining who and what the administrator is. You will see the real substance of this on page 2, lines 20 through 38. This is where we create the temporary position, the administrator, who can be either an attorney admitted to practice in New Hampshire or a retired judge. They would be a temporary employee within the judicial branch. They would receive the same salary as a Superior Court judge. And the appointment of this person would be, this is all in lines 20 through 38, the appointment of this person would be a joint exercise between our office and Claimants Council and the Supreme Court. And what we have suggested is that we would work with Claimants Council to come up with a list of acceptable candidates. We would submit that list to the Supreme Court, and the Supreme Court would make the selection. Under that mechanism, it's possible that we could just agree on someone and the court would appoint that person if we submitted a list of one, because the language allows for a list of up to 5. But if we can't agree on one person, the other option is to at least agree on a list from which the court would pick. So I know Attorney Vicinanzo said that they would want to think about that a little more before they give their final feedback, but that we felt that was potentially a good way to balance, the desire to find a qualified person and to have that person be independent, to have that person still be a state employee somewhere within the state so that we can control costs, which we heard concerns about last time. So this is our attempt to balance all of those things. Obviously, we've put it in here, so I think it's a good suggestion, but that will ultimately be up to you, and I'm sure we'll talk about it further when we've heard Attorney Vicinanzo's feedback.
So before you leave this bullet,
Yep.
I think we were asked 2 things. We were asked to make sure that we had an adequate pool of candidates to where we could get this filled, and
Yep.
I assume you believe that we can do that under this legislation. And the second was whether or not this was going to become a mutually exclusive role, or if the person could maintain an independent practice should they have one. Have you thought about that second one?
So What I don't know off the top of my head is if, I know we have moonlighting rules for state employees, at least in the executive branch, that certain full-time employees cannot have other employment outside of their jobs, cannot necessarily receive compensation for other jobs. I don't know, because we've made this a temporary employee within the judicial branch, I don't know if they have those same rules. From my perspective, if whoever the administrator was felt that they could do both, I wouldn't have a problem with that, even if they're a temporary employee of the judicial branch, maintaining a mediation practice on the side. But I think that would be a conversation to be had when we started working to come up with acceptable candidates, figuring out who we thought would be workable. We'd talk to those folks, and if an individual felt that they were interested but would want to maintain a practice on the side, and in talking with that person, we felt that that could be workable, we'd agree to have them on the list. So I think we could work through that in the selection of the administrator.
Representative Emmerich?
Thank you, Mr. Chair. In accounting, there's a kind of a adage that fixed costs are variable per unit and variable costs are fixed per unit. What we're saying here is we're going to establish a fixed cost for administration, which during the first year is going to be a real deal. During the second year, not quite such a good deal. During the third year, there's 2 cases. Let's say the first year there's 300 cases. Fixed cost of salary, man, amortizes great over 300 units. But when you get to year 3 and you got 2 cases and the same fixed cost, now those become extraordinarily expensive. My thought process is an arbitrator is a variable cost. Can this part-time employee also be compensated on a variable basis based on units or processed?
So we could set it up that way. I mean, we could have the person be, say, a part-time or an employee within or a contractor reporting to the judicial branch, who was paid, on a variable basis, say, according to the hours they put in. I think as I think about it, I think you're right, that this is a better deal maybe in the early years, not so great of a deal in the later years. My sense is a full-time employee, it probably comes out in our favor. If we have to pay hourly for someone for intense hours, even in the first 2 or 3 years, that could be a lot of money. So I think we would save in the beginning, maybe not save on the back end, but it would balance out. But I do think it would be possible to, if the determination by the committee is you would rather have this person be compensated sort of based on work performed, or this person and whatever staff they had to utilize, have them be compensated based on work performed, I think we could set it up that way. I think it's hard to predict what would be a better deal for the state financially.
Follow up? Yes. Mine was not the hour of the administrator. Mine was the case itself. The same range could apply. A case that has, I'm winging it here, these has more than 6 variables, for example, is valued at X. One that has 2 variables is valued at 0.5x, so that the administrator is paid on a fixed rate based on the complexity of the administration, not their hourly rate.
Yep.
But that would allow you to have multiple administrators. If you have 5 people and 3 of them are acceptable to everybody, you could now have 3 administrators on a part-time basis, but a fixed compensation schedule, so it doesn't turn into a kind of a runaway compensation plan. That's just food for thought.
Okay. Yeah, we can certainly, we can think about that.
Okay, thank you.
Yep.
Representative Walsh?
Thank you. I just have a request of the AG, and that is, can you find out if the court rules permit what you're envisioning, and that is that we might have a mediator who continues to take outside cases as appropriate in their schedule? And, obviously, it would be helpful to the committee to know if this is what's possible under the court rules. And if it's not possible under the court rules, I'm wondering if we need to add something in here in the legislation that provides a special exemption to make that possible.
Yes, yeah, we can absolutely find out whether there's anything currently within the court rules or even statutes that apply to the court that would prevent that. And then if we decided that that was a good idea, we could put language in to make an exception in this case, absolutely.
Okay, so now I have one. So Representative Emmerich kind of brought up a workload issue, and I'm just curious. There's nothing in here about support staff. This administrator might need, or is there?
There is, yeah. There's
Okay.
there's permission for the administrator to employ necessary support staff, and that, or for the, I think they would also be temporary employees of the judicial branch as
okay.
necessary. That'd be paid out of the fund.
So that number can breathe. If there's a
Yes.
heavy volume, the administrator can go hire people with the right skill set to provide real contribution to helping with the task.
Yep.
Okay.
And I think to your point, Mr. Chairman, that is an element of this that even as how we've drafted it, would provide for some variability. So while you have an administrator through the entire period of time,
Right.
their support staff may rise and fall based on workload.
Right. I like that. Thanks.
All right, so with that, I'm going to move to number 2. This is a fairly simple change, I think, found on page 2, lines 11 through 13. We just had some discussion at the last work session about not wanting any part of this to be taken as expanding or limiting the rights of individuals under state law or other parts of state statute or state common law. This is meant to be sort of a discrete, I'll just call it special process for this particular class of claimants. And it's also not, any definitions in here, any concepts in here are not meant to be modifying the common law or changing some concept that may exist somewhere else in state law.
I'm going to go ahead and tag you, Representative Lynn. I think this was your point last time. Does this satisfy your concern from?
I'm sorry, not completely, I'm still very concerned about the definition of sexual abuse and including this removing coercion as part of the statutory definition, because I'm very concerned about what the basis for doing that is, and if it's not, I mean, it would seem to me that we're making, in the absence of some other body of law, we're making a basis for the state to be liable, something that does not currently provide a basis of liability under the law, and that's what kind of concerns me.
Well, so I think the case reference, State v. Foss, that really gets to whether the coercion requirement in order to convict of the crime of sexual assault, the variant of sexual assault that you have when you have a person who has authority or power over an individual using coercion. Because we've used the criminal code to define what sexual assault is for purposes of this, civil claims for which we'd pay damages, that's why we're carving that out. I'm not sure that we're removing what the state could be liable for civilly, even though someone maybe hasn't committed a crime. If you're a corrections officer who couldn't be convicted of a crime for doing something, I'm not sure, I'm not aware of cases that have tested that, but I'm not sure that in a similar series of events, someone has had that interaction with a corrections officer, maybe that wasn't a criminal act. There may still be, based on the facts of that circumstance, an ability for someone to bring a civil claim. So I'm not sure we're necessarily creating new liability for the state, but that said, I think we're still dealing with a somewhat different situation here because we're dealing with juveniles. And so what we're really trying to say here is that if someone is incarcerated and they have engaged in sexual acts consensually with a guard, the fact that there was no additional coercion other than the fact that the person's incarcerated and the person they've engaged in the acts with is a guard is not a reason to not consider that sexual abuse for purposes of this statute. The court at the end of the day in Foss was just interpreting what the state statute meant. Not that I would say that I think the court got it wrong, but I think it would be appropriate for the legislature to say, well, okay, for purposes of this, we're not gonna go with how you've interpreted the statute. I mean, because the legislature could always just make a correction to the statute or a change to the statute in response to that ruling. So I know I've kind of gotten not just to your question of are we creating new liability, but also to the question that was raised last time of whether this would be appropriate.
May I follow up? Yeah, I mean, I guess my concern is that if you were saying to us, look, there's a well-established body of civil law that says that someone can be held liable for this kind of sexual assault where the requirements of the criminal statute are not met, I would have no problem with that. But it sounds like we don't really know what the answer to that. Maybe the common law means that, and maybe it doesn't. And so my concern is, why would we say anything? Why wouldn't we just say, why wouldn't we just end the sentence after the citation to the statute? And if it turns out that the civil law of committing aggravated sexual assault does not require that thing, then fine. Then that would. But I mean, it does sort of seem like we're changing the substantive law just for sort of this these set of plaintiffs, and that does bother me.
Yeah, and I will admit there is a slight discomfort to that. I think the reason from my perspective that it makes sense in this situation, although I understand the arguments on the other side, is that we've confronted this on the criminal side. There are certain acts that we can't charge for because of Foss and because of how the court has interpreted that statute. It doesn't necessarily mean on the civil side that we think those may not be acts that weren't appropriate, that could give rise to a potential claim. We don't know, but they could. And since part of this is a settlement mechanism, I think there is an argument that it's appropriate here, because we're doing other things in this legislation that potentially will result in payments by the state that we wouldn't otherwise have to make. I mean, I imagine that there will be claimants that come through this process who, if we litigated, their claims would be barred by limitations. I'm almost certain that would be the case. And we are setting that aside for purposes of this. So this is just one other potential defense, say, that we are setting aside for purposes of this process only. Jen, do you have anything to add to that? I want to make sure I'm hitting everything. Okay. I had a feeling, even though I wasn't even looking at her, that she had something to add.
Justice Lynn, I agree with you that the body of civil law that defines the intentional tort of assault is completely separate from how the criminal law defines the crime of aggravated sexual assault or simple sexual assault. When we were thinking about the scope of this legislation, we thought about how to define the scope. And because the civil scope is so much broader and isn't really applicable to activities that happen within a detention facility, we opted to use the specific definitions in the criminal code that apply to the juvenile detention facility. When we looked at doing that, we felt that that law was just slightly too narrow, in that there is the coercion requirement that has been interpreted into the statute through the Foss case. And our understanding of why that was in the case law was because when you are looking at putting someone into jail for committing the crime of sexual assault, it's important to have the component be that it's clear that that actor took an intentional act, and that is done through the prosecution having to establish this element of coercion. We just felt that that was a little too narrow, and we wanted to broaden it just a little by removing the coercion element. And that's the reason for the reference to the case law. When we were here last time, you expressed a very important concern that that not become somehow engrafted into either the criminal law or the civil law because it's in this process. And so the language that we are proposing is to try to clarify that. And I don't know if that explanation helps or not, but that's how that wound its way into the definition.
Thank you. I don't have any, I mean, I understand your position. I'm still not sure I agree with it, but I understand it.
Okay.
So Representative Lynn, in your opinion, is this an issue that the legislature should take a different position on than the one being recommended by the AG?
I guess my concern is this, is that this is going to be a statute. In other words, I could completely understand that in the context of a particular case, the administrator might say, you know, well, this was under my interpretation of what the civil law would require, someone can be liable, and therefore the state should have to pay, even though there wasn't this particular requirement of state versus force was met. But I guess I would think you could do that even if you didn't have that reference, and to put the reference in a statute, it seems to me that in some sense, the legislature is now sending a message that this really is what the civil law is for all cases, and I don't know that it's appropriate to do that in this kind of legislation. That would be my basic concern for why you shouldn't do it, and I'm not sure that you need it. I mean, I'm really not sure that you couldn't accomplish what you want to accomplish without saying that. So that's my concern.
Okay. We can think about it further too, and maybe even have an offline conversation. Okay.
Yeah.
All right.
Mr. Chair?
Representative Hatch.
Thank you, Mr. Chair. We often do legislation, and in that legislation, we annotate notwithstanding certain RSAs. I'm trying to. We often do legislation that does not comply with certain RSAs, and we so state, notwithstanding RSA, whatever it may be. And just, if I may, and I'm sorry to take the time, I need to understand the difference, what's happening here with that. I think that's kind of what you're saying. This is not totally unique. That's all.
Do you have a response to that?
Yeah.
Do you understand the point?
I do kind of. I don't have a coherent response. I don't think. I agree that we do in certain instances say sort of notwithstanding any other provision of law or notwithstanding X, this will apply for purposes of, say, this section of the RSAs. I think this is a little bit different because we're referencing case law, which is not common. I have not seen that before. Okay. So yeah, I think it's a similar concept to what you'll see in other places in the statute. This is, though, unique. So I think I do have to acknowledge to Justice Lynn's or Representative Lynn's point, this is unique.
Okay, I think we're on bullet 3.
Yep. So this is a set of related but somewhat separate points, mostly just to make sure we've got the incentives and the integrity of the process in the right place. So the first change on bullet 3 you'll see in page 6, lines 24 through 28. And this is in direct response to, I'm forgetting who it was, it might have been Representative Emmerich, someone else, who raised the point that the claimant should know that by moving to the resolution process, the cap on attorney's fees goes up. And so we just wanted to make clear in the legislation that the claimant has to have notice of that. That's got to be clear to the claimant. Page 6, line 36, and page 7, line 2. This comes from some discussion I think we had at the last work session and some follow-up discussion after regarding a concern about the administrator potentially knowing too much about the Attorney General and the claimant's negotiations before the resolution process, and that influencing the resolution process. And so basically what we want to make clear is that while the AG designee and the claimant may engage in settlement discussions based on the initial filing of the claim and the review, that those discussions will not be made known to the administrator if the claimant moves to a resolution process. Basically, you don't want to end up with a situation where whatever the Attorney General offers as a settlement just becomes a floor in every resolution process, or that influences the administrator. And I think the claimant needs to, in order to put the incentives in the right place, the claimant needs to understand that if they go through the resolution process, they could get less than what the Attorney General is offering or more, but it's not guaranteed to be a minimum of whatever the Attorney General's offer is. And then the last change here just goes to, in the last draft, we wanted to respond to the point that some experts had made, which is that it's important for a claimant to have an opportunity to meet face-to-face with the administrator. We wanted to give the claimant that opportunity, but wanted to make clear that that type of meeting alone would not result in the cap going up on attorney's fees. It's not necessarily, that doesn't mean they're necessarily going to the resolution process. They just may feel like they want to be able to say to the administrator that talk about what happened to them, tell their story.
So is this the best section of your summary for us to go off on the sidetrack of the observation that was made earlier today, saying that we ought to let the claimant get further in the process and get to know the dollar amount before they realize that they're now locked in. Is this the right time to talk about that?
I think so. I think this would be a good time.
Okay.
The change that we made in this draft, it's actually a point further down, but given how the discussion flowed with Attorney Vicinanzo, I think this is a good place to talk about it. We made a change in this draft to move the point at which a claimant has to waive their right to go to court from when they file a claim to after they've had discussions with the Attorney General designee and they decide to go to the resolution process. So the idea being that you file your claim. The language Attorney Vicinanzo was referring to that he thought wasn't clear is on page 5, line 3, where it says, by filing a claim, a claimant waives their right to simultaneously seek relief in court. What that is intended to accomplish is to say, if you file a claim, you're not giving up your right to go to court, but you are essentially agreeing to stay any lawsuit that you filed while you go through this process, so that we avoid a situation where now you're going through the process set up by this bill, you're litigating at the same time. That doesn't just create a resource problem, I think it also creates practical problems, because we might be engaging in discovery over here, taking depositions, trading information, and then we're going through a separate process at the same time. It's just not, it's not, I think, the ideal situation. It creates a number of problems.
So I think I get the simultaneous issue.
Yep.
The other part of what was being said, though, and just because it's simple to me, is that the claimant ought to know what the state is offering in a dollar amount.
Yep.
Before they lose their right to go back to court. What are your thoughts on the timing of that?
So my general thoughts on that are this. I mean, it's not a couple points. One, high level, I think the point was made, and I think it's a good one. If we do that, it removes, I think, much of the purpose of this legislation, because all we've done is set up a much more complicated mediation process than we would undergo if we just tried to mediate this. So I think it removes the purpose of the legislation overall. I also would say it's not the concept of going through an arbitration process as an exclusive alternative to go to court is not an uncommon or strange concept. I mean, this process is intended to be, if you elect the resolution process, it's intended to be a kinder, gentler, simpler process by which you are more likely to get something at the end of the day, maybe less than if you went to court, but that's the alternative you're electing. It's meant to be an alternative option. It's not meant to be a pre-litigation mediation. So while I understand that getting to wait and see what your award is before you have to waive your rights to go to court, that would be certainly positive for a claimant. I think we've talked a lot about balance in this, trying to balance the rights of the claimant, balance our obligations to the taxpayers, balance the desire to provide a kinder, gentler process while also providing fair compensation. I think we're getting a little bit out of balance if we do that.
Representative Lynn?
Yes, and I apologize, Mr. Chair.
No apologies. I'm
I-
honored to have you here.
Well, no, I have an issue about an earlier point that was made about, you mentioned, and I think it's a very good, way that you've drafted this. On page 6 at the bottom, you note that the AG and the claimant may engage in discussions that do not, which they don't tell the administrator about.
Yep.
But the thing I'm concerned about is on if you go back to page 5 in line C, in section 8C, it says, once a claim is considered complete, the AG designee will have 30 days to indicate to the claimant and the administrator its position regarding the claim. And so I'm just concerned that may be, in other words, does that, what is envisioned by that? And then also in subsection D on the next page, it says following receipt of the AG's position. And I'm just wondering, I mean, that would tend to suggest, unless there was some different language, that would tend to suggest that the administrator is going to be aware of what, of what the AG sort of thinks about the case, and which may be inconsistent with the administrator not knowing that.
Yep. So I think, and I'm gonna let Jen jump in on this too after I finish, because she and I talked extensively about this. But there's a distinction between the Attorney General wanting to. The claim is going to set out what happened, how much under the guidelines they think that's worth, and the Attorney General has the opportunity to look at that and give a position. I think there's a distinction between the Attorney General maybe saying, yes, there's sufficient evidence that we believe also there's, say, sufficient evidence that this happened, or at least nothing to indicate this didn't happen for, let's say, allegation 1 through 3, not sure there's sufficient evidence that allegations 4 through 5, or there's something that would call into question allegations 4 through 5, part of the complaint. We would want the administrator to have that, because it's important for the administrator to have kind of the general view of the Attorney General's general view of the claim. That doesn't mean that the Attorney General designee and the claimant might not then, as part of that conversation, say, okay, well, we have real questions about this. You've said X. We've got questions about Y. While we might be inclined to say this to the administrator, we would offer you an amount of money to settle the case. And I think that's what we don't want the administrator to have.
Okay. No, I see how, I appreciate your clarification, and I understand what you're saying.
Okay. How'd I do? Okay, great. Yeah. Why don't you just add it,
I don't have anything to add to that. specifically. The only other thing I would add is that I think this also goes to the plaintiff's counsel's concern that the plaintiff needs to understand the state's position before it exercises the waiver by having the Attorney General's designee weigh in on which parts of the claim analogous to an answer in litigation, which parts of the claim the Attorney General believes should be paid, that is the state's kind of first offer, and then the claimant would be asked to make the choice whether, based on that offer, they want to now leave the process and go to litigation, or whether they want to move forward through the resolution process with the administrator. The decision at that point would be between two different processes if they don't like the state's offer, but they would have the information that I think counsel is looking for that to be an informed decision.
Mr. Chair, may I just follow up with one point? You know, I'm just wondering, and again, I understand what you've said, and that may, the way you have it may be fine, given what you've said, but I'm just wondering if you wouldn't be able to accomplish what you want to accomplish without giving the administrator knowledge that might, you know, sort of intentionally or unintentionally cause him to cabin in what the value is going to be. If in Section C, you simply said the AG will have 30 days to indicate, right now it says to claimant and the administrator. What if you just said we'll have 30 days to indicate to claimant its position regarding the claim? And then in D, if you said, you know, following receipt by the administrator of an indication that the AG has informed the claimant of its position, you know, then certain things will happen. That way the administrator wouldn't have the information really at, you know, sort of at all about what the AG's position is until after the, you know, you and the AG's designee and the claimant have not been able to come to an agreement. Then you would provide, then you'd go to the administrator to have the administrator resolve it. I just.
And we certainly could structure it that way, but I think as a practical matter, as soon as the claimant were to make the election to go to the administrator, we would still want to then provide the administrator with our position anyway as a starting point for moving forward. I didn't envision that the AG designee would ever back off of a position going into a resolution proceeding that they had told the claimant was what they would resolve the claim for, what they thought it was worth.
Okay. Fine. Thank you.
All right. So I just want to let you know you're not doing very well managing your 45 minutes.
All right. Let's see if we can make up time.
All right.
Yeah. So moving to number 4, further clarification and improvement regarding installment payments. We've discussed this a little bit, and Mr. Early discussed this a little bit, but after having consulted with some folks that I think it was Representative Waltz suggested we consult with, we thought it was a good idea coming out of the discussion last time when we talked about the option for a claimant to take any award in installment payments to add a third option. We started with 2 options. One was lump sum. One was the state pays out the claim in installment payments of up to 10 years. We added a third option, which is the claimant can essentially elect that their, let's just call it $250,000 award, be used to purchase an annuity from a company. And so it'll be that company that they've purchased it from that pays out the claim. That also gives more flexibility. That annuity might not be 10 years, it might be more, but it's an additional option for the claimant that doesn't really change the hit to the state, because it's not really any different than the state paying it all in a lump sum to the claimant. In this case, the claimant's using that lump sum to structure something with a third party that provides a little more flexibility.
So does the state end up making a recommendation on which settlement route they go, or who they might use if they want a structured settlement?
We do provide in here that the administrator will maintain a list of of companies you could use for this purpose.
Right.
But we have removed the provision based on concern we had last time that the administrator could impose installment payments over the claimant's
Right.
objection.
And so is that list off of some vendor list that already exists, or is there, do you imagine a process of where you would bar somebody from being on that list?
I think it discretion of the administrator. The language says the administrator may maintain that list. I think it would be up to the administrator in consultation with whoever they think is appropriate to have a list of recommendations. It certainly doesn't mean that the claimant has to take someone from that list. Just it would be used to assist the claimant. So number 5, I know we've already had some discussion on this, but this change came out of the discussion at the last work session regarding how important these guidelines are going to be, the process and the guidelines. We've added provisions that would provide that after the Attorney General and Claimants Counsel meet to figure out what the claims process and guidelines will look like, that has to be approved by the Fiscal Committee. The reason for that, I think, is that the guidelines, however they look, are going to be very important in determining how and where claims land between $0 and whatever the cap is. The guidelines are going to be very important in determining, really, at the end of the day, how much money may go out the door. And so I think I detected last time a discomfort from this committee with just delegating that out to the Attorney General and Claimants Counsel and having it never come back before elected representatives. And so the idea here is that Claimants Counsel and the Attorney General would meet and agree on a set of process and guidelines that would be presented to the Fiscal Committee, and the Fiscal Committee could either approve or the Fiscal Committee could object and articulate concerns, which would require Claimants Counsel and the Attorney General to bring back a revised proposal for approval. So that was our attempt to address, I think, what was a desire to have a last check by legislative representatives on these guidelines. I understand, and I think at this point I'll address Attorney Vicinanzo's concern. I understand the concern that provides sort of another point at which there could be disagreement or the process could go off the rails. I think we have to balance that concern with the competing consideration that, to the point you made, Representative Edwards, this is taxpayer money, and without some form of approval of these guidelines, there's a lot of delegation being given to determine how much money is going out the door to just the Attorney General and Claimants Counsel. So I think this is ultimately a determination for this committee, given that you are the legislature, so you can represent the legislature's interests. I generally think that's a good idea. I mean, it's something we would recommend, but again, like all of this, it's a determination you have to make in balancing those considerations. I have confidence that we could work with Claimants Counsel to come up with something and then make a very good presentation to the Fiscal Committee. So I don't have the same consternation over the process as Attorney Vicinanzo does.
Representative Walsh?
Thank you, Mr. Chairman. Mr. Attorney General, are you aware of any other time in the state where the legislature weighs in on the settlement terms of a civil action involving the state? I mean, I've been here 14 years, but I am unaware of anything, but that certainly there's a lot of things I don't know. And I'm wondering if this is a unique animal or if there's another occasion where the legislature gets a say in those kinds of things.
Yeah, great question. Thank you, Representative. So the concept is not foreign because I think it's RSA 1435, I'm forgetting exactly the citation, provides 1435E for any settlement over, I think it's 0.25% of the last fiscal year's total revenue. The legislature would have to approve that settlement. I think that number's around $4.6 million. So let's take a separate case from this. I could not go out and settle a case with another claimant for something else for $5 million without having it be approved by the full legislature, but through an actual act of legislation. So this concept is somewhat similar to that, given how much money we're talking about here, but this would be a simpler approval mechanism because it would just be the fiscal committee as opposed to bringing these guidelines back as a bill. Now, this is a little different because in this case, the fiscal committee would not be approving, say, just a dollar amount or terms. The fiscal committee would be approving sort of a piece of this settlement process. But I think while it's a little bit different, it's a concept that the legislature has contemplated before because that's built into 1435E. Yep.
Could you, while we're talking money, could you address another couple of points? One is there's concern that for physical abuse only, 150 cap would be arbitrarily low. If you could address that, and then given that since we've last met, we have expanded the scope a little bit of what we're going to cover. And I'm just curious if it's your position that 100 million is going to be adequate.
Yes, thank you for that. So I think there's a couple different points in there. So the first one I'm going to take is expanding this to include physical abuse claims. And so I'm going to skip ahead to a bullet that's on our list. Over the course of these discussions, I think we've talked a lot about that, whether this should just cover sexual abuse claims or whether it should be broadened to include physical abuse claims. I think as we've thought about it, we've really wrestled with it. And as you know, my position has been that this should just cover sexual abuse claims, given the difficulty parsing through physical abuse claims, whether there might have been a reason for those claims, the need to see records to determine whether those claims happened. I think, or whether the events that underlie those claims happened. I think as we've thought about it, we can resolve the concerns with the difficulty of verifying physical abuse claims and the difficulty of parsing through potential defenses by including them within what's covered here, but accounting for the potential difficulties in verifying them with a lower cap on what we'd pay out. It's all about, I think, balancing what I see as a desire on the part of the state and on the legislature to compensate claimants for harm they've suffered, but balance that with verifying whether alleged acts have occurred and also accounting for what the state's exposure would be if we went to court. Because at the end of the day, this is taxpayer money, and so I would struggle with the idea of paying an amount for claims that's a lot more when they're worth. So that in trying to balance all of that, I think we feel that including physical abuse claims in the scope of this, but with a lower cap, is a good place to balance that. The second point...
And it's also the case that if there's a claimant that believes the 150K cap is too low, they have the ordinary processes that they can leverage.
Yes. If a claimant believes that cap is too low, they can go to court. I want to address a point that came up in the earlier discussion, which was the caps themselves, 150,000 and I think 1.5 million, and they were described as arbitrary. I just want to respectfully disagree with that. I think as we have stated in past work sessions, we've done a lot of verdict research to first come up with the $1.5 million cap. We've provided that to this committee. We think based on those numbers, 1.5 million is important is appropriate because with that cap, this process can be designed in a way where the claims that are paid out sort of fit roughly with the national average of these types of cases. The $150,000 cap is based on looking at physical abuse claims within the verdict research we've already done. The rough average there, it's lower. I think it falls between 65,000 and 75,000. And so that's how we determined a $150,000 cap. So while I would fully acknowledge that someone may disagree with the research we've done or think other cases should be included in that research, I do not think it's fair to describe those caps as arbitrary. I think they're based on verdict research. The other point I want to address is this. there was a reference to other caps that the legislature has already established. The cap in 1435E and the cap in, I'm forgetting the site, but the $325,000 cap, I think it's in 541. The 1435E cap is a settlement authority cap. That is meant to limit what the Attorney General can do with regard to settling cases without coming back to the legislature for approval. Based on the formula, that's about $4.6 million. So I think that cap is not the same as the type of cap we're talking about here, or the type of caps we're talking about here, which are caps that we've determined based on what we think would be fair amounts given what these types of cases have settled for in the past. The $325,000 cap, that's also not a cap that's meant to value a particular claim. That is what I'll describe as a sovereign immunity cap. It basically says that the state is only, that you can only get up to $325,000 per incident for various claims against the state. But that's a general cap that could cover anything. It's not the same as the type of cap, again, we're talking about here, which is for a specific type of claim that we've been able to do research on. So I think, that while I understand that claimants counsel may think that $150,000 is too low and $1.5 million is too low, I would submit to you that what we would need to see to assess that is other research or additional research regarding what types of payouts have happened in these types of cases. I don't think the numbers we should be looking to determine whether those are too low are the cap provided for in 1435E and the $325,000 cap provided for in 541. I think those are different numbers that have been established for different purposes, and they don't really fit with what we're talking about here. So that's how I would respond to that point.
Okay, so about 2 weeks ago, I understood that you all were open to having independent research provided to you should the 1.5 million ceiling be challenged. Did you ever receive any independent research to challenge?
No, we have not received that to this point.
So Representative Wiley, you have a question?
Thank you, Mr. Chairman. General Formella, while you were doing your research, has any work been done to show these settlements have improved a person's feelings or their life or anything? Has anyone looked into that, or they've gone on as miserable as ever, or have there really been improvements?
So it's a fair question, Representative. I mean, I'll start by answering that as no, we have not done that level of research. I think that's because what we're trying to do is determine what an appropriate number is to account for what the state's exposure is if we go to court, and to account for or to determine how you just value these cases generally from a damages perspective. It would be very hard for us to do general research on whether someone who has suffered terrible acts of abuse, whether the money helped them, how much good it did them. I think that's a really case-by-case, fact-specific inquiry that's difficult to conduct, because I don't think there's a lot of folks who are then tracking people who receive these monies and tracking how well or how much of a positive impact that money had for them. I think it's fair to say that many who have suffered sort of terrible acts or incidents of abuse, we've talked about this before, no amount of money is ever going to fix that.
Well,
so it's hard to measure the positive impact that the money has. What we're really trying to determine is, what are those cases worth? What are the damages that flow from them?
we're finance. We like to see results. Thank
Yep.
Okay, and to carry on with that just a little bit further, I think I took a business law class in 1979, and the history seemed to be that it was generally accepted for decades, if not hundreds of years, that financial compensation was the primary way in which you tried to make somebody whole.
Yep.
I mean, if you can't go back and remediate the harm, then the financial compensation for damages is just the standard and common way that we do this in society. Is that fair?
I think that's fair, and I think the reason is because I think we have historically struggled in many cases to come up with a better way of remedying harm than just to pay financial damages. There are times when we do, but the more straightforward way is financial compensation.
Thank you. Representative Mooney?
Thank you, Mr. Chairman. Thank you for taking the question. Perhaps it's been said and I missed it. Do we have any idea what the total amount of individuals housed at the detention center is from its founding until the present day?
So I don't know the answer to that question. I think it's something we could determine. I mean, it's a fairly large number, but I don't have that number for you.
I've listened to Mr. Lipman before, and they have stats on all of that. So
Yeah.
I think to jump in and answer the question, it can be determined. They have the records to do that. Would you like that done? Should we send a request to Mr. Lipman to pull that together?
Thank you, Mr. Chairman. I think so, only because this is just an attempt to sort of sharpen the focus as to what we're talking about in terms of numbers. We've heard multiple times that there are between 400 or 500 alleged victims. I think it would be helpful to the committee to know what percentage of the full residency that would be.
Okay, because I'm going to ask Mr. Ripple to send the email to Mr. Lipman. So just to make sure we clarify exactly what you're asking, you want the total population that's ever gone through YDC from patient one to resident one to when? To today or to the beginning of 2022? What's your range?
The beginning of 2022 would be fine.
Okay. Do you have that, Mr. Ripple? All right, thank you. Representative Long?
Thank you, Mr. Chairman. Would that include duplicates?
I think it, yeah, if the same resident had been incarcerated more than once, I suspect that the number that we are asking, the way it just got phrased, would include some repeat offenders.
So if somebody was there 3 times, that would be 3.
I don't know. I don't know how good Mr. Lipman has a database to screen that out, but I think in each of those incarcerations represents a chance for violation. So although the number could be padded in a sense, I think it still gets at the kind of scope that Representative Mooney's looking for. Is it? I don't want to speak for you, though.
If you don't mind, Mr. Chairman, it sounds like that may be 2 categories of counting. I was referring to individuals. It sounds like Representative Long may be referring to those that have been sentenced there or placed there. So sounds like we may be getting into 2 categories. My original thought was individuals. How many individuals we're talking?
So you're looking for unique individuals. If they've been in there 3 times, then you still just want to see them reflected as 1?
Correct.
All right. I think Mr. Ripple can ask for that. I just don't know how great their database is to help go through that sort of a sort. So we'll try to get the best data we can from them. Representative Walls.
Thank you. I'm just going to suggest we give poor Mr. Ripple a start date. I don't know how long it's been there, but for example, anything before 1940, I can't imagine is going to be relevant because I can't imagine those victims might still be alive. And from the infinity in time, I'm just suggesting we come up with a reasonable start date.
That's a great request, and I fudged that by knowing that we gave up on the 1980 start date, and we can go back further. I don't know when we first opened up a YDC, though. But your point is valid. The people could have aged out or passed away. So, Attorney Ramsey.
May I weigh in, please? So I think a way to make this not quite so monumental a task for the department would maybe be to start by asking them what they have available to them through their electronic records. I do think that there is the ability to run a search back to a certain point of time, and then they would have to start looking at handwritten records. And 1940 would be a predecessor facility that moved in and out of agencies that no longer exist and had a board of trustees. And I think theoretically it might be possible, but it would be an enormous amount of work for the department to go all the way back. So I don't know if that would answer your question, Representative Mooney, but I do think the department could fairly quickly give you a number of what they maintain electronically and give you that start date.
All right, so I think she's agreeable to that. And then, so obviously, if we limit it to electronic records, then we just want to know when the date begins so that we can interpret the data. Representative Umberger.
Yes, whatever they are, the plaintiff's lawyers have indicated they're 500 people. So maybe they could tell us the earliest date that would then give us perhaps an idea of where to start rather than trying to pull something.
I don't know if we should ask you something like that, but do you want to provide that answer to us?
Earliest victim is from 1963. The vast majority are after 1975, but earliest is 63.
Okay, so I still think we may end up being high-centered around the idea of what's in the electronic records, but we now know that if it went back to 1963, that would. 53. I heard him say 63. Yeah. Okay. All right. And my hearing's not so good. All right. So I think we've gone on, but you never answered the question about is $100 million going to cover this?
Yeah, and I know I've been asked that before, and I know my answer before has been it depends. You know, it just is hard to predict how many victims will eventually come through this process and what amount they're going to get based on what we see regarding their allegations, what we see when we look at it and give our position. It's also going to depend on where the guidelines land. So is $100 million enough? I think there is a reasonable possibility that it will not be enough at the end of the day. It's hard to know that now. And it will probably be a couple years, or at least a year, 1 or 2 years before we have a sense to see kind of where this is going.
So I understand that answer. The basis of my question was that we've expanded the scope of who might be covered, and the incremental expansion of scope. I'm just curious, and I don't need it now, but
Yep.
It'd be interesting to know how the scope expansion is going to affect the pot.
What I can say on that is this. First, we've expanded the scope, but the cap is a lot lower. But second, based on discussions we've had, and I don't want to go into details on this, and I can't make guarantees based on this, but based on discussions we've had with plaintiffs' counsel over months, my understanding of the value of these claims is that adding physical abuse only, adding the folks that say have physical abuse only claims would not. We're not talking a magnitude of doubling or tripling the state's exposure. It's a percentage that I don't view as extremely significant in the scheme of the amount of money we're talking about. I know that's very vague, but I just can't give you exact numbers. But part of the reason we've recommended this and recommended a lower cap is that if these are the values that you set, these are the caps that you set, based on my understanding of who a very high level understanding of who the physical abuse only claimants are, I don't think we're talking about a major expansion of the exposure to the state. But that will depend on where these caps end up.
Thank you. are you ready for point 6?
Yes. So point 6, page 7, lines 8 through 10. This was just to clarify that claims will be processed in the order that they are received as complete, not just in the order that they are received, to address the concern that someone might rush to get an incomplete claim in to get to the front of the line, take a while to make their claim complete, and then they're at the front of the line. You don't get your place in line until your claim is complete. Point 7 is on page 8, lines 33 through 34. This just represents Chairwoman Umberger's point that there should be more frequent reporting to the fiscal committee. The original draft had annual reporting. We've changed that to be quarterly. I think we have already talked about point 8, which was expansion of the scope to include claims of physical abuse. So the one additional point I'll just add on that concept is that as part of the expansion of the scope, we have also revised the factors that the administrator would, or that the guidelines would consider to account for the additional challenges of evaluating physical abuse claims. So for instance, those factors include, how long ago the events took place, whether there were records available that corroborate the events or the allegations. Those are the type of factors we think we should include if we're going to include physical abuse claims, because that accounts for some of the difficulties in evaluating those claims and whether there are defenses and whether they happened. So point 9 is just some more technical changes that were made to account for some of the other process changes we've made that we've already discussed. But for instance, because we are now suggesting that the administrator be appointed after the guidelines are approved, we've just had to push back the notice deadline, for instance. So that has moved, I think, from October to December. That's a little bit of a guess, right, as to what an appropriate deadline is to get all that stuff done, to get the notice out and start the process. But we have December in here. The reason I think we can be a little bit ambitious with that deadline is that even though the administrator won't officially be appointed until the guidelines are established, it doesn't mean that we couldn't be working in parallel on the tasks of negotiating the claims process and guidelines, and also talking about potential administrator candidates for us to submit to the Supreme Court. So I think the hope would be is that we work out the guidelines, we get them approved by fiscal, and very soon after we're ready to submit a list to the Supreme Court, who I think we can be confident the court will be helpful to us in acting on that quickly. So that's where the kind of the December 1st date comes from. We could always move that back, but I think my experience is giving everyone an ambitious deadline to work to that's not too ambitious will keep things moving along.
So we heard testimony that suggested that we've got the order wrong, that we should hire the administrator before we come up with the claims matrix. What are your thoughts on that specific observation?
Yep. So I think one of the primary points there from Attorney Vicinanzo was that the administrator could be helpful, perhaps, in mediating that discussion between claimants' counsel and the Attorney General's office on what those guidelines should look like. While I see that point, I think there's also an argument to be made, and I lean towards this argument, that the administrator, who is going to be the ultimate judge that makes determinations on what an award should be, shouldn't necessarily be involved in writing the law, if you will, that they're going to be applying, right? We don't have judges draft the laws they're going to apply. I think working out the guidelines and then handing them to the administrator and saying, here's essentially the law you're operating under for purposes of this is what you will be applying. I think there's a pretty strong argument that there's more integrity to that process. That said, I think from our perspective, we're open to thinking about that differently, but that's why we have recommended for now setting it up in that order.
So I have a two-part question. One is, should we get some experience with this and we think that the ranges just were wrong for a category or multiple categories, is there a process or what would we do in order to relook the claims matrix to see if it's, needs to be tweaked?
So the process that this draft provides for is that the matrix can be tweaked by agreement of claimants counsel and the AG, but by coming back to the fiscal committee for approval of any revisions.
Okay, and then the second question is, you guys are putting so much work into this. Is there benefit of having the administrator on board a little early anyways to help relieve the administrative workload of the AG's office to get this established?
So I would say, yes, there's always benefit to relieving the administrative burden. I do think a lot of the work that will happen prior to the administrator coming on is negotiation. It's really the negotiation regarding what the process and guidelines look like. When the administrator comes on, it's their job to take that and implement it. I'm not sure the administrator can relieve us of the work we would be doing aside from them. The work they're going to be doing doesn't really overlap with the work that we'll be doing before they come on board.
So just to challenge that idea, so you'll be sending out the public or the press releases to all the different media that we've talked about before the administrator gets there?
No, I think the administrator is responsible for that. So the administrator, once they're on board, they're responsible for putting out all the notices. And,
Right.
Yeah.
All right, so is there any value in front-loading that so that, we can get the ball rolling?
Well, I think it depends, because I think the notice really shouldn't go out until the guidelines have been adopted, because I think part of the importance of the guidelines is that gives notice to these potential claimants of what they're signing up for if they decide to come through this process. And I think that addresses a concern that's been raised. At the end of the day, this is intended to be an alternative option to traditional litigation. So we want claimants to have ample advance notice of what this looks like before they even start to think about signing up, because they don't have to sign up for this. And if an individual claimant thinks it isn't fair, or it's not enough, or it's not going to provide enough relief, they can go through the litigation process. Keep going. All right, so that, I think, brings us to point 10, which we have talked about, but this, we discussed it previously, so I'll just hit it quickly. This is the change where we have moved the point at which a claimant has to waive their right to go to court from the filing of the claim to the moment where they have to decide whether to take whatever they've been offered by the Attorney General or go to the resolution process. Under this draft, if you decide to go to a resolution process with the administrator, at that point you're waiving your right to go to court. So that's that change. And then point 11, we just put it on here. We haven't put sunset language in here yet, but it's on our list to do. It just is, we need to know, we need to be close to the final place of what provisions this will contain before we can say which provisions need to sunset and which provisions shouldn't sunset.
Do you have any alibis? You got things that you want to add to that? I'm sorry, military term. Do you have any additional comments that are not on your summary, or that previous testimony raised some issues that you weren't prepared beforehand to deal with? Is there any, you got any strays?
Yeah, I'll hit a couple. Just on the right to know concerns, and I know Ms. Timmons is going to take a look at that summary and bring it back. I just want to reiterate that what we're trying. Let me say this: transparency, I think, in this process is very important. But what we're trying to do is balance the need for transparency with, I think, the need to have at least the option for privacy for victims who might come through this process. And this is a pretty unique process that we're setting up. And it's why I've said before, and I would say it now, I don't think the 91A just process of balancing the privacy interests with the interests of the public is a good mechanism to apply to this process, because part of making a victim comfortable with going through this process is some level of certainty on how much privacy they're going to be entitled to. So I would be uncomfortable with just relying on 91A. If there are additional tweaks to the language that we have here, or the exemption that we put in here that someone wants to recommend, I think there's room for that. But I just wanted to hit that I think not relying on 91A is probably not sufficient. And I'll just run through. I think I've hit a lot of the points that were provided in Claimants Counsel's outline. Yeah, I think I've covered everything that I wanted to cover. I'll just look to Attorney Ramsey in case there's anything she wanted to say.
At the last work session, there was a question asking us to look into whether there was any sort of a national database that we could look to identify potential claimants that might be in other state facilities. I have looked into that and wanted to let you know that we've not identified any kind of a database like is requested. The only thing that we could identify that might be able to be used is there is a professional association of administrators, of corrections officers, and there is a directory that organization publishes. It would be possible that the administrator could reach out to the leaders of other states' facilities and just request as an accommodation that they circulate the word within their facilities. But we did not find any way to identify by individual a mailing address, if you will, and send a letter directly to that individual.
I forget who asked that question. I think that was you, Representative Walz. It still seems like there's an avenue to try to find people who may be incarcerated in other states. Do you understand where we're at? Are you okay with that?
I do. You know, it is what it is. If it doesn't exist, I mean, I asked if there's a national database. The answer apparently is no. If that's the case, I commend them for coming up with another alternative, and that is to try and find a way to reach out to those facilities and publish the option here.
Oh, all right. Anything else, Attorney Ramsey? I got Representative Lynn.
I just one question on section 10 on the bottom of page 7 over onto 8. Am I correct in understanding that the last sentence of that section, which says the conduct of such a meeting shall not be considered a part of the resolution process and shall not be available if a resolution process is requested until after it is completed? Am I understanding that means that meeting shall not occur until after the administrator has rendered a decision?
Yes,
Okay,
and that
okay.
was to address the concern that, sort of that private moment with the judge, right?
Right, which suddenly the
Yeah.
value of the claim goes up or whatever.
Yep.
Okay, now that's fine.
Okay, so I just want to walk through the timeline, and well, go ahead, Representative Walz, before I do that.
Thank you. I think before you get into the housekeeping, there's something I want to say as I'm sitting here listening to all this and looking at the latest of this as best I can look at it kind of on the fly. This process is only going to work if the plaintiffs buy in. And the plaintiffs' attorneys have, I know, been trying to work with you to create a process that they think their clients are going to buy into. And I'm going to go somewhere that I've never gone before in the legislature, and that's actually to a Hollywood movie. And that is, on last Friday, I did the bar review, my CLEs, and one of them was Ken Feinberg. I don't know if either of you watched that. And at the beginning of his CLE, Ken Feinberg, for those of you who don't recall, was the mediator who settled all of the 9/11 cases. and has done quite a few since then, but he's best known for the 9/11 cases. Here, I can take this down for a minute. At any rate, he announced that the movie Worth, that both he and his kids, and if his kids are like available on Netflix, if you have Netflix. But it was really interesting because a lot of what the movie focused on was sort of the evolution of Mr. Feinberg and his staff in understanding the needs of the victims and sort of bending a bit of their process to meet the needs of the victims and trying to get the victims to sign on. And they had set a goal that they had to have 80% of the victims sign on or they thought that it wouldn't work. And they're sitting there the day before the deadline and they got 55% of the victims. And of course, there's this dramatic end where they do some of the correct moves and make some of the correct considerations so that they end up with 97% of the victims signed on to that process. But it was an evolution over 2 years that you sort of see in that movie of how everybody on both sides got there, how they got there to meet the needs of the victims and how the victims got there to realize that this really was a fair settlement. And I bring that up because that's really what we're trying to do here. We're trying to find that sweet spot where it limits the exposure of the state and where it also provides a system where the victims are going to say, yes, this is a process that works for me. And there's a couple of things in here that concern me that we're not going to get the victims to sign on to this. We started with a more trauma-informed process. I think we are moving away from that to some extent. I think the change in the language about whether there's a presumption the victims are to be believed is part of that, and that concerns me. And I guess I just wanted to say this to say, let's keep in mind what we're trying to do here. We're trying to set up a process that the victims are going to buy into. And that's not easy to do. I'm not naive about that. And so I'm just trying to encourage everybody here to get to that point because I think it's in everybody's interest to have a system that the victims will buy into because every lawyer in this room and probably a lot of other people know litigation is never a great way to go. It's just not. It's really hard on everybody. It's expensive. It's emotionally draining. It's just tough. And we have the potential here to come up with a system that doesn't re-victimize these victims by making them go through the litigation. So I guess what I really wanted to say is let's keep in mind this process of what we're trying to do. We're trying to get to something that is protective of the state and the state's exposure, but also is something that the victims are actually going to be willing to accept because I'm not sure we're there yet.
You're free to respond if you'd like.
Yep. No, I mean, I'll start by just saying this. I absolutely agree that, that this is tough and we really want to get to a place where as many victims as possible will participate. I also think that we should keep in mind that we probably will never get to a place where every single victim will participate. And we also won't, this is one step in kind of, I think, as this bill is setting out a process that will play out even after the bill is passed. It will depend on what the guidelines look like, what the process looks like. So it's going to be hard to guarantee participation. The last point I'll make is this, and there's no way to make this point without sounding a little cold, and I don't mean it this way, but we want the victims to participate, but I think I, as Attorney General at least, have a responsibility not to have that become so dominant of a consideration that we pay out more money than is fair, because I think at the end of the day, there's no question that the more money that's available, the more attractive this process will be. And we want this process to be fair and attractive enough that it provides a good option, but not so attractive that we're simply paying more than the state really should be paying when you look at what these claims would be valued at based on past settlements, based on what the state's exposure is in litigation. At least that, as the state's attorney, I think I have to express that view. Ultimately, there are policy considerations that the committee, I think, can take into consideration that might lead you to a different conclusion. But I just felt it was important to express, I think, where we come from as the Attorney General's office. It's balancing, I think, the desire that Representative Waltz articulated and also balancing, I think, what is our obligation to not recommend that the state do something more than we think it really should do based on the risk. Again, we can make that recommendation, then the committee can decide to do something different, but I think our recommendation needs to stay consistent with that duty that I have.
All right, thank you. Any further questions or comments from the committee members? Is there anyone out in the audience that feels compelled to speak up? We're closing in on the end here. I'm not seeing anyone. So I'm gonna ramble a little bit, and this is for Mr. Hoffman, Mr. Ripple, Representative Umberger, and of course the AG's office. Where I think we are is that if we look at Tuesday, March 1st, it's really like right upon us. Is there any rational way in which we can take all of the feedback that you've gotten today, turn it into, version 3 of the AG's world, and then Mr. Ripple, Mr. Hoffman, I think the thing that we vote on needs to come through OLS, doesn't it? We're not going through OLS now as we're in the work process, but what we vote on needs to be OLS validated, right? So I'm seeing a yes on that. So are we even in the area of the doable with that kind of a timeline, given that the claims attorney wants to take some time to think about the appointment of the administrator? Can we get that done? Representative Umberger, what do you think?
What I would recommend is that Kevin take what we have here to OLS. Okay, and get us a draft from OLS for Tuesday, whatever day it is, and I'm sure they can turn that around without a problem. This is not a heavy time for them. And then all of us know at this point what's in here. So if people have recommended changes, then they need to come to us and say on line 25, page 6, this is my recommendation for new wording. And then we can turn that around and not come in and say, well, I don't agree. If we don't have something to replace what's currently here, we can go on until June and never get resolution. So I guess that I'm just saying that, the AG will make the recommended changes and he'll come back, kind of like he did and say, page 4, we need to make these changes. And if the plaintiff's attorney comes in, he needs to say, this is what the language I want for choosing the administrator. Because otherwise we're going to be in this, and then I think at that point we can either say, how many of you agree with what the Attorney General has in that area? How many of you agree with the changes that have been recommended by, Joe Jones?
All right.
Okay. So it'll, I hopefully it will, speed up the process. There's no doubt that we're going to have another meeting.
All right. So
after the first.
So as you two were taking notes, did you take any notes that tells you that you want to go to version 3, or did you just confirm that version 2 is a good place for us to be?
So I'll let Jen weigh in on this too. My sense is we wouldn't have a lot. We'd have some pretty minor changes coming out of this, at least for now, that we would recommend. So I don't see a lot of robust changes for a version 3. So I think what we could do one of two things to be helpful on Tuesday. We could either bring another revision, or we could come with any changes we have, kind of a list instead, so that, and that, it's kind of what I know happens sometimes in the process. There's a vote on a change without seeing the exact language, and then, okay, we approve that change, go do language. We could come with a list like that, because if you're going to send something to OLS today and have that in front of you on Tuesday, it might be confusing for us then to have another red line, as opposed to a sheet of what I would imagine would be, if any changes, for the purposes of Tuesday, fairly minor.
I think I'd like to go a third way.
Okay.
And I'm trying to respect my chairman's feedback, and
Yeah.
what I think I heard you say that makes sense, though, is let's get what we can over to OLS immediately, under the belief that we're really getting close, okay? And that gives OLS an opportunity to create a document for us on Tuesday that this group can choose to move potentially to the Finance Committee. I'd like to get that document so we can at least say yes or no to a specific approved document. Is that?
With whatever changes they might
Sure.
bring in.
People could still come back to us, right?
Right,
I get
right,
that.
on
but-
Tuesday. Mhm.
But can you, given the lateness of the day and the fact that it's predicted that we're going to do another snowmageddon tomorrow, that can we get something to, is this coming to you, Kevin, or to Mike? To go to OLS? Who's going to, okay, can you get sort of what you think is a thumbs up to us, and specifically to Mr. Ripple, so he can get OLS cranked? Because I'd like a formal document Tuesday.
Sure.
Okay.
Yeah, I think any changes we'd have at this point, we could do fast. And so we could get that to OLS quickly, I think in time for them to turn it around by Tuesday.
All right.
Yep, send it to Kevin, and then Kevin can.
Yeah.
send it where it needs to go.
Representative Lynn?
Yeah, thank you, Mr. Chairman. You know what, the only question that I had, and I may be misinterpreting Attorney Vicinanzo, but it sounded to me like many of the things that we have sort of, that we have talked about and that you've talked about are things that it may be that he would end up being able to agree with. The one thing that it seemed to me, and correct me, I guess I'd say correct me if I'm wrong. The one thing that it seemed like was a big point that he objected to strenuously, and I guess I'm just wondering, have we sort of, at least tentatively, kind of taken a position as a committee on this, is the issue of whether the basis of liability should be extended beyond sexual abuse and physical abuse to other things, because that seemed to me to be a big point of his, which we haven't focused on. I mean, just speaking personally, I'm perfectly content with leaving it exactly where it is, but I don't know how everybody else feels about that.
Okay, so to that end, I'd like to just see an informal show of hands of the committee on whether or not you think that the scope should be extended to include physical abuse only, because that was the new thing in the scope today.
And Mr. Chairman, isn't that already in this proposed bill that we had before us today? That it includes physical abuse?
It is, but to Representative Lynn's remark, we don't have a sense of the committee specifically on this issue, and it's fairly significant. And so I would like you to entertain a request to do a show of hands on whether or not the physical abuse addition to the scope should be included, or if we want to have that removed.
Mr. Chair, can I just raise a point of clarification? I think what I was really asking is, I guess I was, and maybe wrongly so, but I was sort of assuming, just from the lack of comment from other people on the committee, that we were sort of generally agreed that physical abuse would be covered. My question was more, Attorney Vicinanzo said it should be even further than that, and that was what I was, You know, are we sort of comfortable, what I was really asking is, are we sort of comfortable leaving it to sexual abuse and physical abuse and not going any further than that? That was my question.
Okay, so I'm fine, we'll get there. But the first step in this journey, I think, is just to find out if people are okay with adding to the scope claims that deal strictly with physical abuse. All right? So, Representative Umberger, do you want to vote for all of us? Oh, okay. So, all right, so raise your hands if you think the addition of the physical abuse to the scope of this legislation is something you can support.
Mr. Chairman, I have a question before we vote. It's Representative Walls.
Okay, this is just an informal vote,
I
by
know,
the way.
But I still need clarification. Does physical abuse include solitary confinement? Because that would address the vote here.
So the next question on this is what you're asking is the second vote we're going to take, I think, to explore Representative Lynn's question about whether or not we're okay with the definition as written. So you're not, I can tell, because you would like solitary confinement included as part of the definition of physical abuse. I get that. I just want to do this, take 2 bites of the apple instead of eating the whole thing at once.
I want to understand what I'm voting on, that's all.
Okay, so I'll say it one more time. All we're doing with this raising of hands is demonstrating whether or not you support adding physical abuse by itself as a basis of filing a claim. Because until we got this version, it was only sexual abuse in which physical abuse was a contributing factor. This version makes it its own independent, I'm not a lawyer, but it makes it open up to its own claim. Okay? All right. So with that, do you have a question or are you raising your hand? Okay. Raise your hand if you think that we should be adding physical abuse to the scope of claims. Physical abuse alone. No. That fit. Okay, we're adjourned.
Chairman Edwards,
Okay.
So if you're able to send us something fairly quickly, we can get all that to OLS. Otherwise, I think maybe we'll just send what they have right now, and then they can work from there. I don't know what your time frame is.
Okay, let us confer.
Can you give us 5 minutes?
Yeah, let us confer and then go ahead.
I found one typo while we were sitting here. That's currently the only change I would suggest, and I can give it to you in handwriting, but if the general wants me to make any other changes, I just need to know.
You got this version. Sorry, I didn't need this printed on you right after.
So I didn't.
Just for future reference, you gotta be careful you get that right. This version?
Yep.
Doesn't line up with this. You have 2 different versions that look very similar.
Yep.
Yeah, okay. She should have clarified.
Okay.
See, there's a difference? not italicized, but other than that, they look kind of similar.
Yeah. So
Can I see what you've got there?
it might be that's.
This one lines up with this.
Right.
That one lines up with my green markings over here.
And where did this one come from? Just curious.
It was handed out today. I assume from you guys. I don't know. This happened the last meeting as well.
Yeah,
when
no, 'cause-
Representative Long brought something in that also had numbers.
Yeah,
that
this
didn't
is
match
just
up.
different. Yeah, because all this italicized.
Well, that's yours. That's the good one. That's the bad one.
This is the one we handed out today.
Correct. Well, that's the one that matches.
Is it? This
Yes.
it is?
Yes.
Oh, okay. Oh,
That
so
one
you did
matches.
italicize instead of you didn't keep the red lines in it.
I'm just saying, you got to be careful. This is the second time we've had documents that don't line up, and I can't
Okay.
follow along.